Call the meeting to order. It is 8:40 a.m. and if anyone wants to participate is welcome to, but we're strictly voluntary, not required. I'm going to ask Commissioner Garza to open us in prayer.
Again, everyone bow their heads, please. Lord, we thank you for this day that we get to come together, the commissioners, and serve this great state of Texas. We ask that you guide our decisions today, that you speak clearly through everyone coming today presenting their cases, Lord. We ask that you continue to be with those that are still affected by the floods in Houston and in the area, that the department and agency can provide their assistance in any way that they can to assist those individuals. Lord, we ask that you give us a great day today. You bless everyone here. In the strong name of our Lord Jesus Christ we pray. Amen.
Amen. Tamla, will you call roll, please?
Chairman Rick Figueroa.
Here.
Vice Chairman Tom Butler.
Here.
Dr. Ray Callis.
Here.
Commissioner Helen Collier. Commissioner Nora Castaneda. Here. Commissioner Joel Garza.
Here.
Dr. Gary Morton.
Here.
You have one.
Welcome, Commissioner Castaneda. It's good to have you here. And John, welcome on board. I heard you drank out our fire hose yesterday, so that's excellent. I need a motion to accept the absence of Mr. Collier.
So moved. Second.
All in favor?
All right.
So we're going to move items on the agenda N and O. We're going to move it to audit since their burn rate is higher than ours. We're going to move them up to the front. So let's go ahead and deal with the audit first. If you can ask the auditors to come up, that'd be great. And Commissioner Butler, thank you for chairing that.
Good morning.
Morning.
Dan Graves with Weaver, the agency's internal auditor, or outsourced internal audit firm. And so appreciate you moving the agenda item around this morning for us. Before the meeting started, I believe you got a copy of our internal audit status report. We had 3 different audits that we performed this year. We've completed all our internal audit plan that was proposed for fiscal year 2019. The first internal audit was a report over the process of licensing. And while we completed that report we completed our fieldwork in March and issued that report in May, the report had an overall rating of satisfactory. And so just as a refresher, we have 3 different report ratings overall. We have strong, satisfactory, and unsatisfactory. And so this received the satisfactory rating. That satisfactory rating is based on the fact that we had 7 different findings, 1 of which was high risk and 6 of which were moderately risk rated. And so each one of these items that we identified in this year's fiscal 19 internal audit is on the 2020 proposed internal audit plan. The next 2 reports were both follow-up reports of prior internal audit findings. And so the first one was a follow-up of prior internal audit findings. And so if you recall last year when we started with the agency, we had multiple internal audits dating back to 2013 that had 18 different findings that were open. Last year we followed up and showed that 11 of those were remediated. So of those 11 that were continuing to be open this year, we identified that 5 were fully remediated, 1 was partially remediated, 1 was closed, and we closed that due to the fact that it related to another internal audit finding that we had identified in the Enforcement Administration audit, and so we just closed it so that we weren't misrepresenting, to use the number of open audit findings. And then 1 that was open, and so still had some continuing action by the commission or by the agency to completely remediate. And so the 1 open finding and the 1 partially remediated finding are both on the 2020 proposed internal audit plan. The last audit was a follow-up over Enforcement Administration, and so this was the first full audit that we did for the agency in last fiscal year. We identified last year that there were 6 findings. Of those 6, 3 we identified were fully remediated, and so all corrective action had been taken and put in place, and then the remaining 3 were partially, so there had been some action taken and shown progress, but there was some continued effort that needed to be made through the rest of fiscal year 2020, and we will follow up on those as well. The last report that we have before I do that, there is a table presented, and so you'll see on pages 3 and 4 of that summary, just a status tracker of all the different open internal audit findings, and you'll see on the last page is a total page where when we started with the agency, there were 32 internal audit findings that were open. As of today, there are only 12, and of those 12, 10 of those reside in fiscal 18 and 19, so the last 2 full internal audits we did. So that's a tremendous amount of progress I want you guys to be able to see as part of the efforts of the agency to actually close out prior internal audit findings. The last report we have is our annual internal audit report. And so this annual internal audit report is required by the Texas Internal Audit Act. It's a prescribed format that is given to us by the SAO, and we have reviewed that with the audit committee and gone over all the elements of that report, and the report that we prepared is in compliance with the requirements from the SAO, and once that is approved by the commission, then we will send that report as well as the 3 internal audit reports that we've completed to the SAO, the LBB, the Sunset Commission, and the Governor's Office as required by the Texas Internal Audit Act. In that report is the 2020 proposed internal audit plan. And so those are the last couple pages of the packet that we handed out. And so the proposed internal audit plan for next year, or actually the current fiscal year, is an internal audit over revenue. As the agency's grown and taken on new licensing, we felt it prudent to review that area and conduct an internal audit over the revenue cycle. So this would be all revenues from all different licensing as well as the legislative appropriations process. And you'll see that we have both the follow-ups over licensing and all the other prior year internal audits included as part of that plan. And then just for your complete sort of viewing and package, the tentative plan for 2021 is actually an internal audit over contract administration, as well as follow-ups over any other open internal audit findings. And so we will represent that next year for a approval, but that's just some forward-looking plans for you as the commission to see what's on the horizon. So with that, that concludes my report, and I'll open for any questions.
Mr. Chairman, first of all, I want to thank Vice Chairman Butler for chairing this audit process. I move that we approve the fiscal 19 annual audit report and the fiscal 2020 internal audit plan.
A second.
Any discussion?
If I may, Mr. Chair, I just wanted to thank the employees of the agency and our partners at Weaver, the amount of work that y'all have done in the last year to bring the issues that were high risk down to satisfactory is a tremendous amount of work. And I want to thank Dr. Callis as well for being on this commission. For the new members of the board, those on the finance committee, you can probably tell an audit committee are some of the better looking members of the board. So Nora, we will expect to see you on this commission. And that's all I have.
Don't quit your day job, Commissioner. All right, we got a motion, we got a second. All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you for your work and appreciate your time today.
Thank you.
Mr. Chairman, Brian France, if I could just add, I want to really commend Carla and Tony Cuvie on the work they do to help usher through these improvements. They stay on top of it. They have just a lot of instinct and a lot of, they have the ability to make it happen, even when the plates are full for our employees, to make these things happen and make them important. So I really appreciate you and Tony for what you all have done. Thank you.
Thank you, sir. All right, we're going to go to Tamla. Do we have any public comments? Okay, perfect. All right, well then, we'll go into executive session to consult with our attorney under section 551.071, section 2, and 551.071, section 2, government code at this time, and it is 8:50. Thanks. All right.
Put me on the other side.
Okay, we've concluded our executive session. Time is 9:17. Looking at, you guys, gentlemen, or ladies and gentlemen, you've got to look at your minutes for the meeting. I need a motion on that.
Make a motion to approve.
Second.
All in favor? Aye. Motion carries. All right, we're going to go to item G on the agenda, which is contested cases. If you're here today for a case and you wish to speak to the commission, you'll be called up. We will call upon you and announce your case. We'll hear from the prosecutor first, and then we'll hear from, you have an opportunity to speak. Make sure you fill out a public comment form, which I have here, and you'll handle it to Ms. Fletcher over there. Make sure you speak into the microphone. Please state your name and who you represent if you're an attorney. The commission can only consider information, this is important, and I want you to make sure you hear me on this one. The commission can only consider information that is in the record when the case was heard at SOA. So you must limit your comments to those matters that are presented in the SOA hearing. So I want to make sure that's understood. First case is Brandon Rollerson and Ken Sharp. Mr. Brown, is that right?
Yes, sir.
Okay.
Yes, sir.
So much.
Mr. Rollerson, is that you? You didn't fill out a form. Are you not going to speak?
He hasn't filled out a form yet. He should, we were a little late. We just weren't sure. Well, we thought we were going to get
Okay,
the
Tamara,
SO office.
can you make sure he gets the form? Be great, just for formality's sake. Thank you, sir. I appreciate your time. Okay, Mr. Sharp, floor is yours.
Thank you, Mr. Chairman. Commissioners, good morning. My name is Ken Sharp. I'm with the Enforcement Division here at TDLR. The respondent in this next case, or in this first case rather, is Brandon Rollerson. Mr. Rollerson was first licensed as a Class A barber in 2004. After the hearing, the administrative law judge recommends that you revoke his Class A barber license. In 1996, he was arrested and convicted for resisting arrest and sentenced to 3 months in the Lamar County Jail, but the judge suspended that sentence for 6 months. And then in 2010, he was convicted of possession of marijuana, more than 2 ounces but less than 4 ounces, and sentenced to 30 days in the Dallas County Jail. Now, although he was only convicted of possession of marijuana, when he was arrested, the respondent was in possession of 46 individual packages of marijuana, with the marijuana itself weighing just a little over 4 ounces. Okay, we had 2 things go on, or 3 things, go on in 2016. First, in May of 2016, Mr. Rollerson was convicted of attempt to commit possession of marijuana more than 4 ounces, less than 5 pounds. And in that case, the police officers had stopped him for a traffic violation, and they discovered that he had 3 black plastic grocery bags filled with individually packaged units, I guess, of marijuana, or baggies of marijuana. There were 37 of those packages in those grocery bags. Well, that led to a research of the respondent's home, and there they found 2 shoe boxes and 2 glass jars that were filled with additional individual baggies of marijuana. And the total number of those packages of marijuana that he had was 140. Then in October of 2016, he was again convicted of possession of marijuana. That arrest occurred when the police stopped a respondent for a traffic violation. They smelled marijuana smoke in his car. When they searched the car, they found 4 different individually wrapped, in fact, vacuum-sealed packages of marijuana. In that case, the police also found a 9mm handgun loaded with 12 rounds of ammunition and another magazine that had another 12 rounds. And for that, the respondent was convicted of unlawfully carrying a weapon. Now, notably, those 3 possession of marijuana convictions and the unlawfully carrying a weapon conviction all resulted from negotiated plea agreements, and that typically involves a plea to a lesser charge or a lighter sentence, or often both. Mr. Rollerson was 22 years old when he committed his first offense, resisting arrest, back in 1996. He was 42 years old when he committed the most recent offenses. He renewed his barber license in 2014. He had the 3 convictions in 2016. He applied to renew his license again in 2017. And on that renewal application, it asks a question that you've heard before. Since your last license was issued, in this case 2014, Since your last license was issued, have you been convicted of or placed on deferred adjudication for any criminal offense other than a minor traffic violation? And Mr. Rolson answered no to that question, but because of his convictions in 2016, that answer was false. Now, at the hearing, Mr. Rolson offered no explanation for submitting a false answer to the criminal history question. He merely testified that he was only convicted of possession of marijuana and not delivery, but he did not deny having been involved in the illegal distribution of marijuana. He also downplayed his unlawful possession of the firearm by suggesting that it was just a technical violation, since he happened to possess the firearm at the same time he happened to possess more than 2 grams of marijuana. The ALJ had expressed concern over the resisting arrest conviction back in 1996 because that conduct that resulted in that charge showed a propensity for violence. He also observed that the carrying of a firearm was an offense under the criminal conviction guidelines, the offenses against persons guidelines from the department, because, as the ALJ put it, someone might be interested in the drugs he was carrying and he might be compelled to use that firearm. The ALJ also noted that another reason for placing that in the offenses against the person category under the criminal conviction guidelines is because barbers they work in circumstances that could lend themselves to confrontation. Now, one of the criminal conviction guidelines for categories for barbers is also crimes involving the illegal delivery of a controlled substance. The guidelines do not specify the exact crime, the exact title of the crime. And a good reason for that can be seen in the respondent's May 2016 case, which clearly involved a marijuana distribution operation, as evidenced by the fact that he had 140 individual packages of marijuana. Even the 2010 conviction where he had 46 packages of marijuana, that would support that as well. But through the negotiated plea agreements, as indicated before, he was able to plead guilty to the lesser charge of possession of marijuana and got a lighter sentence. Even though the ultimate charge after the plea bargain was mere possession of marijuana, the offense he committed involved the delivery of marijuana. The ALJ failed to recognize that the possession of marijuana conviction in 2010 and the 2 additional possession of marijuana convictions in 2016 involved an illegal marijuana distribution operation, in the first 2 cases especially. But he did, however, conclude that since the 2 most recent convictions for possession of marijuana occurred within 5 years before the date that the respondent applied for renewal of his license, that the Commission is authorized to revoke the respondent's license on that basis. And finally, the ALJ found that the respondent knowingly made a false statement on his renewal application. And because of that, along with the respondent's failure to respond to the Department's request for information when we had made that request about his criminal history, the ALJ concluded that the respondent lacks the honesty, integrity, and trustworthiness to hold a license. The ALJ recommends that you revoke the respondent's Class A barber's license, and the department asks that you adopt the PFD.
Sharp, thank you so much. Hey, by the way, great job. I like your timeline.
Oh, thank you. Good, I hope it helps.
Alleviate a lot of the confusion. Okay, Mr. Brown and Mr. Olson, did you get a chance to fill out the form? Okay, we'll just leave it there, be fine. Again, we want to restrict comments to the SOA hearing. We can't, anything that wasn't in that hearing we can't hear, so just want to make sure you guys understand. Okay?
I understand
And
that.
make sure you state your name and who you represent.
Good morning, Commissioners. My name's Alex Brown. I'm here representing Brandon Rollerson. I'd like to start off by actually requesting that we continue the hearing. I was hired only a week ago and haven't had adequate time to prepare for the hearing. However, we are prepared to proceed generally if necessary, but again, we filed a motion with SOA. They told us that I'd have to present that motion here today to continue the hearing, again, because we haven't had adequate time to prepare for this. I understand Mr. Rollerson had his hearing in February and has had opportunity to hire an attorney. However, he did not quite understand the seriousness of the situation, and once he did reach out to hire myself here in town, and again, he's from Dallas and had to come into town actually yesterday for this hearing. We've done what we could to prepare for today, but as his legal counsel, I would like to request a continuance today to revisit this, so we have some more time to prepare.
Mr. Sharp, you have any comment?
Uh,
Mr. Bowman?
yeah, Mr. Chairman, this is Brad Bowman, General Counsel. So that would be the first, I think, order of business for the commission to take up would be that motion for continuance. I think Mr. Brown also submitted a written motion, which you should have.
Correct.
And then you may want to hear from the prosecutor
That's-
on that.
Good job. Mr. Sharp?
Thank you, Mr. Chairman. Well, we would oppose the motion for continuance. We didn't oppose it the last time he asked for a continuance back in August when the commission met at that time. That's true. We had the hearing in February. The PFD was issued in May, but that's 2019. This thing has been going on since 2017. And that's when he filed his application for renewal. And then I think it was in early 2018 when we sent him the first NOAV, the Notice of Alleged Violation. We didn't get anything back from the post office, so we sent a first amended Notice of Alleged Violation. And we not only sent it regular mail, but we also sent it certified mail. We still didn't get any return confirmation from the post office, but neither one of those came back. Nothing has come back so far. So we sent yet another one, a third Notice of Alleged Violation. Now, this is taking up time as we do this. Again, certified mail, and again, by regular mail. And again, neither one of those came back, but the post office said, no, we don't know. We don't know what happened. So then after that, we said, okay, well, we're going to see what we can do here. And we sent a Notice of Intent to Default. And we sent that. And then when we sent the Notice of Intent to Default, then we got a response back from Mr. Rollerson. And he said, well, I want a hearing. Okay, so we set up the hearing. But by now, like I think 6 months have gone by when we're trying to get him to respond to our notices of alleged violation. We set up the hearing. We had the hearing in February. And if it was not evident from the Notice of Alleged Violation or the Notice of Default, it certainly was evident from the hearing, the tenor of the hearing and the explanations that we gave at the hearing about the intent to revoke his license. So the seriousness of it should have been evident to him at that time. We got the proposal for decision in May that said his license should be revoked. And then the commission meeting was set for August. And he says, well, I want to hire an attorney, so can we continue this? Okay, well, we don't oppose that. So we continued it from the August meeting to this time. And now he says, I want another continuance because now I've hired an attorney. And I think just since the late 2017, since this thing has been going on, it's just too much time. We need to get it resolved.
Commissioners, you got any questions? We'll handle the continuance first, and then if we want to hear the case, we'll hear it. Any comments?
Mr. Chairman, this is Brad Bowman again. Just for the record, wanted to, in fairness, the August continuance, we mailed out the notices for that meeting late, and so we granted some additional leniency to respondents that wanted to request a continuance, and this case was one of those. So just wanted to, for some context, that's not advocating one way or the other whether you should grant the continuance, but just for the record, so that first continuance was a little bit out of the norm. It was partially on us, is what I'm saying. So just for your
But the notification he was notified at what date of the continuance?
That was for the August commission meeting, so we sent out those notices late. And because of that, we were granting some additional leniency. So there's some cases that were held over from that
Right,
meeting.
I remember. Right.
For this one, and that was one of those cases.
So
I
when
just
did he
wanted to-
receive that notice, is what I'm asking?
We called, I think, July 31st. We did send out written notice also, but it was not within the 10-day time frame that we normally, that we normally.
Okay. And I think it states here that the attorney was hired in September 24th.
That's correct,
That's
Your Honor.
correct. Okay, so that gap between them, okay. All right, Commissioners, we need to address the continuance first. Any comments? Any questions?
Was he represented by an attorney at that first hearing?
No, sir.
Okay, just represented himself.
Yes, sir.
I make a motion we deny the continuance.
Is there a second?
I'll second.
All in favor, say aye.
Aye.
Opposed? Okay. Continuance done. All right, you can go ahead and give us your best shot.
Well, thank you, Commissioners, for hearing my request for continuance. I appreciate that. Again, we have only had about a week to prepare, or I have only had about a week to prepare for this. However, Mr. Rollerson, at the time of the first hearing, thought that there wouldn't be any other opportunity after appearing there to actually make an argument. He thought the decision would be just made. However, that's neither here nor there. Mr. Rollerson is not obviously denying that he has criminal convictions, and we'll work through those a little bit, and then I'll get to his license renewal. He's indicated, well, rather, he's actually never been charged with possession with intent to distribute, and that is a separate charge, obviously, from possession. He's been arrested for possession of marijuana, but never actually been arrested for possession with intent to distribute, despite.
And this is outside the record, by the way.
Okay, you gotta contain, again, the caution is you gotta contain it within what the SOA hearing.
Your Honor, I would argue that it's actually on the record what he was charged with and what his criminal history is. And
I mean, sir, what he was charged with and what he was convicted of are two different things. He could have been charged with it, but he was convicted of something different, correct?
we do have the actual PC affidavits from.
Yeah, the charging instrument,
Well, the PC affidavits would indicate what he's been charged with for most misdemeanors here, and those were actually entered into the record. As far as I can tell, that's what I received from what he had from the record. The PC affidavits from each case showing why he was arrested, and at no point.
the indictments there.
I don't believe we have the indictments.
He could have been charged with it, is all I'm saying.
What I'm arguing here, Your Honor, is the police officers who arrested him did not believe what he had was intended to be distributed. We also have that he was arrested and his house was searched in his 2016 attempt to commit possession. And in searching his house, they found a significant number of sealed baggies of marijuana.
140.
Correct, Your Honor. However, if we look into that a little bit, those sealed baggies were not just Ziploc bags, and there was nothing to indicate that he had anything on him to actually seal those baggies. He merely purchased marijuana for his own use.
This is not in the record.
I believe Mr. Rollerson testified at the initial hearing and responded that he did not ever intend to distribute marijuana and that the marijuana was for his own use.
It's not in the record.
We can't consider it. Our goal is to see if there was any misapplication that the ALJ had in
I understand,
adjudicating
Your
these
Honor.
cases, right? And so we put a lot of emphasis on the ALJs. I mean, they're the rubber meets the road scenarios, so it's very difficult for us to get too granular into this. However, I understand what you're trying to contest in front of us, but again, we want to stay within what the SOA hearing has, because it's not fair. Does that make sense?
I understand, Your Honor.
Okay, so however you want to position that, it's up to you.
Well, the state argued that the ALJ failed to consider that he was arrested for distribution of marijuana. However, I'd argue that that's a mischaracterization of what happened. The ALJ confirmed and held that he was arrested and convicted for possession. You can't read farther into that beyond failing to consider that he was never actually charged with possession, and I believe the implication was that he should have been. Now, I believe we're also allowed to discuss rehabilitative efforts at this time.
But we didn't at the hearing.
You didn't compare it at the,
No, there was just one letter of recommendation is all that he submitted. It was
who's that from?
Respondents Exhibit 1 from someone named Jason Washington, the manager of the establishment Trendsetters Barber and Beauty Shop.
Mr. Washington and Your Honor, I understand I can't bring this in, but did write another letter. That is essentially Mr. Rollerson's boss, although he rents a chair and isn't directly accountable to him. Mr. Washington does run that barbershop, and this letter that Mr. Rollerson brought in last time indicates that that's not it. That Mr. Washington believes that he's a good person and does not distribute any kind of marijuana.
Actually, it doesn't say anything about distributing marijuana, it just says that he believes he's a good person in so many words.
Right.
Well, that he is a good person and would like to continue working with him.
Understood. Question?
Yeah, Mr. Rollerson, got a question for you. In 2017, when you renewed your Class A barber's license, what led you to falsify that document to state you've never had any criminal history?
Honestly, we had got a call that there was an inspector from another barbershop, that the inspector was in the area, and my license was expired, so I went home on my lunch break.
And this wasn't any evidence.
I went home to fill it out, and I had customers waiting on me, so I just figured that I would just put no and then straighten it out later. And then I never did, though. It's kind of a time constraint.
Well, I understand, but I mean, in accordance with the following rules for licensure, full disclosure is always something that is recommended. Even me, whenever I license for Texas Medical Board, I have to make sure that I maintain the integrity, the principle, the leadership that is warranted on me by the state of Texas to practice medicine, just like it is for you to practice barber. With that being said, I find it hard to continue to allow you to have a license due to the fact that you could have corrected this problem and something differently. I don't know what, Mr. Chairman, I don't think, personally, I don't feel like we need to discuss any longer. I'm ready to vote.
Okay, we'll hold your motion because I want to make sure everybody gets, I got you. Any other comments or questions?
I have a question, Mr. Sharp. The charge for, or the conviction of unlawfully carrying a weapon so he does not have a license to carry? Or is it because he was in possession of marijuana that the charge comes along of carrying a loaded weapon?
It was because he was in the possession of marijuana. As I understand it, it was in his car, and I think there's that law that allows a person to keep a gun in a car, but not when the person is intoxicated or in possession of unlawful substances like marijuana and controlled substances.
And if I may comment on that weapon, according to Mr. Rollerson, was purchased legally. You can prove that if we had some more time to show the receipts and all of that. But
And that wasn't an issue at the hearing, and it
At
wasn't in the record either.
At that point, again, the charge was arising merely out of committing any other criminal act while having a firearm in your vehicle or on your person.
Okay, thank you.
Commissioners, any other comments? Any other comments? Okay. Sharp?
Your Honor, I actually do have a comment. We would ask that if you are considering removing his license, that he be put on a provisional license for a year to prove that he can actually follow the rules here and be essentially follow all of the licensure rules and not commit any other acts or anything like that that would jeopardize that. We would just ask that you be put on a provisional license.
Appreciate it. We know the gravity of taking a person's vocation away from them. We understand. I mean, it is, and thank you for the comment. All right, so, no other questions? All right, Commissioner. You got a motion? You're considering?
Yeah, I'm considering.
All right, I'll give you a minute. I'll give you a
Give me
minute.
a little-
We're not on a stopwatch.
Mr. Chairman, you had asked me if I had any other comments.
Yes, sir.
Could I offer a couple?
Yes, sir.
One thing is that insofar as the actual charge that he pled guilty to or was convicted of, the possession of marijuana, you are allowed to draw reasonable inferences from the evidence. And the evidence that somebody's in possession of 140 individually packaged units of marijuana is highly suggested and certainly would warrant a reasonable inference that that person is in the marijuana delivery operation business. The second thing, but even if it weren't, it still was within that 5-year period, so it still serves as a valid basis for, or authorization for revocation of the license. Also, something that Mr. Rollerson said was that he had called an inspector, or somebody had called and they got word an inspector was coming, that he needed to get his license renewed. And the day that he renewed his license, he said he went home and renewed his license. We introduce license history whenever we do these hearings. And the date that he renewed his license had been expired for several months. But apparently, according to what he said, he was still working. So an ability to follow the rules and not commit crimes from 2010 through 2017 has already been exhibited.
Thank you, Mr. Sharp.
Mr. Chairman, for the record, if we revoke his license, when can he reapply?
Mr. Bowman, 1 year?
There's a 1-year bar to reapplying, so after that year, he would be eligible to reapply, and then he'd have to go through the process at that time. So it's not guaranteed at the end of a year that he could get his license back, but he'd be eligible to reapply at that time.
And for you non-lawyers, there is a glossary that you can pull from. You need to.
Mr. Chairman, Brian Francis, there's just one comment that our counselor made that had just a little bit of concern about the inference side of it. I think we need to deal with the convictions that are in front of us, not what we think may have happened or what's inferred by that. You have convictions for possession, and the implication that we can make inferences of what really went down, I think, is outside of what you have in front of you. You have convictions.
Okay.
I have a question.
Yes, sir.
Mr. Rollerson, is this marijuana for your personal use?
Yes, sir. And if I may state, the person that I used to purchase from, he would always already have it packaged.
Is this, I'm sorry, is this in the
This
record?
is in the record.
None of it's in
Oh,
there.
I'm sorry. I'm sorry.
Just answer the question, if you don't mind.
Okay.
Okay.
Make a motion that we adopt the PFD as recommended by the judge.
Is there a second?
Second.
All right. All in favor, say aye.
Aye.
Opposed? Okay, motion carries. Mr. Olson, this isn't your last stop, so you actually, you'll receive a copy of our decision with a cover letter that explains the next steps in the process if you want to appeal our decision. By finally a motion for rehearing. If you have any questions, the staff will be happy to walk with you. Appreciate your time. Sorry that we saw you in the circumstances, and hopefully it'll change for you.
Thank you.
Thank you, Commissioners.
You did a good job, Counselor. Thank you.
All right, next case is Ms. Martinez.
Thank you, Mr.
Sharp.
Chairman. Ken Sharp from the Enforcement Division here at TDLR. And I also have another handout coming to you,
Timeline, isn't it?
something along those lines. Yes, sir.
Brilliant idea.
Yes. Wished I'd have thought of it myself.
Mutual admiration, just.
For the slower ones, this is gold, I would say.
Well, the respondent in this case is Lisette Martinez. The administrative law judge recommends that you revoke her massage therapist license because the law requires it. In February 2009, Ms. Martinez pled guilty to and received a deferred adjudication for the offense of prostitution. She was placed on community supervision for 1 year. Now, that was in February of 2009. 2 months later, in April of 2009, she was issued a massage therapist license from the Department of State Health Services, or DSHS. There was no evidence whether DSHS ever conducted a criminal background check, or if they had, they would have found what happened 2 months earlier. Now, that's significant because of two laws in the massage therapy statutes in the Occupations Code that affect eligibility for a license, and I've got copies of the pertinent parts of that in that handout there. The first one states she is not eligible for a license, a massage therapy license, because of her guilty plea and the deferred adjudication. Either one would do it, but because of those things, she's not eligible for a massage therapist license. Excuse me. The second statute says that if she has a massage therapy license and pleads guilty to or is put on deferred adjudication for the offense of prostitution, the law requires that license be revoked. In any event, from what we can tell, DSHS, we don't know what information they had, but in any event, as time went on, it doesn't look like they applied these statutes consistently or uniformly when they addressed these problems. But Ms. Martinez got the license, and DSHS renewed it regularly. Then in 2017, TDLR assumed responsibility for administration of the massage therapy laws, just as the legislature directed us to do. Now, we began conducting criminal background checks on all licenses, all license applications. That would be new license applications and renewal applications, because that's what we do here. We 100% background checks on all license applications. And then it was during that process that we learned Ms. Martinez had been placed on deferred adjudication after her guilty plea for prostitution. Now, those statutes are clear. Ms. Martinez is not eligible for a massage therapy license. And to the extent that she had one at that time, the law requires that it be revoked. We notified Ms. Martinez about the laws, about how we had to administer those laws, and that we had no choice. She requested a hearing, and so we had one, and that's why we're here today, of course, to resolve this case. But this case has broader implications because this is the first one of its kind to come before this commission. And it's important to note, too, that this is not the usual kind of case that you see. Ordinarily, we bring these types of cases here based on Chapter 53, the statutes in Chapter 53 of the Occupations Code. And that gives you a lot of discretion. But this one is not that kind of case. This case falls under Chapter 455 of the Occupations Code, the massage therapy statutes. And those two statutes that are in that handout that I referred to earlier, those statutes require revocation or a determination of ineligibility. There's just no choice in that. The legislature specified clearly a direct result. But anyway, this is the first case that TDLR is to resolve under these statutes, and the first one to be resolved here after the legislature directed TDLR to take over this program. So we're here with that one. Now, in this case, the administrative law judge found that these statutes were unambiguous, they were clear, and any person who has pled guilty to or has been put on deferred adjudication for prostitution is not eligible for any kind of massage therapy license. And if a person has such a license, under those circumstances, that license must be revoked. It shall be revoked. The ALJ recommends that you revoke Ms. Martinez's license, just as the law requires, and the department asks that you adopt the PFD as it's written. These statutes are not new. They've been around since the 1980s, but it's new to us, and it's new to the commission. So if you have any questions about these things, I'll be glad to answer.
Mr. Chairman?
Yes, sir.
We are not responsible related to DSHS renewed respondent license back in 2016, but we are responsible for TDLR. And it's crystal clear to me, based on the statute, that we should follow the PDF. So I move that we respect the PDF and follow that as a motion.
Okay. Just to confirm, is there anybody from Ms. Martinez that's here? I want to make sure that that's... Okay. All right. Well, there's a motion to accept the PFD. Second? All in favor?
Aye.
Motion carries. All right. Case number 3, Ms. Tang. Mr. Sharp, get comfortable.
Good morning. Good morning. I'm Charles Medlin. I represent Ms. Tang, and she is present, but I'm not going to be asking her questions or asking her to give any evidence today. But she is present. Stand up, Ms. Tang. And she's here with her husband.
Okay.
And they're here because they're interested in it, but I'm not going to be asking her to participate.
Go ahead and have a seat, sir.
Thank you,
We'll
sir.
hear from you in a minute. And thanks for filling out this form. Again, we're going to have to stick to the SOA hearing context, please, if you just don't mind.
That's
I know
what I'm hoping for.
It's a very lucrative offer to go outside that, but we want to contain it. So after Mr. Sharp, we'll give you an opportunity.
Thank
Okay?
you.
Mr. Sharp?
Thank you, Mr. Chairman. More handouts coming your way.
Timeline.
And I did provide counsel, I already provided counsel with one, or with a copy, rather.
Go ahead. I
Thank you.
apologize.
Thank you, Mr. Chairman. Ken Sharp with the TDLR Enforcement Division. The respondent in this case is Wei Tang. Ms. Tang holds a massage therapy license that was issued to her by the Department of State Health Services, the DSHS, in 2014. In 2016, police officers in Montgomery County conducted an undercover investigation at a massage therapy establishment. The evidence admitted at the administrative hearing showed that Ms. Tang solicited an undercover police officer for sex in exchange for money while giving him a massage. The officers arrested Ms. Tang for prostitution. Now, although the arrest was for prostitution, Ms. Tang and her attorney negotiated a plea bargain to which she pled guilty to the charge of disorderly conduct. The factual basis of the charge, the disorderly conduct, was contained in the information. That's a document. It's kind of like a complaint or an indictment, but it's in the information. That was the factual basis for the charge. And I included that, those things in the handout. The first page is a copy of the actual order of deferred adjudication. The second page is that information, the factual basis. The information very clearly states she offered to engage in sexual conduct for a fee, and that's prostitution by definition. Now, even though the title of the charge was not prostitution, even though the title of what she pled guilty to was disorderly conduct, the offense she committed involved prostitution. And
Excuse me, Your Honor, I'm going to object to that. It's a summary that's not in the evidence at our hearing. It is a misstatement of the law, and I would object to that statement.
I got you noted. Was it submitted, was it in the SOA hearing?
all of this was in the hearing, yes.
Okay, anything in the SOA hearing is
But he's not allowed to make a misstatement of what was in the hearing. And that's what he just did, and I'm objecting to the misstatement.
The misstatement is what?
The misstatement was that she had been convicted of a sexual offense, and that's just not true.
And that's inaccurate.
That was our argument all along. She was convicted of an offense involving prostitution, and that's what I'm talking about here.
But the conviction was what? The conviction wasn't.
The title of the conviction was disorderly conduct.
That's what
The
we knew, okay.
the basis.
That's your note.
Yes, sir, and if he misstates it again, I'm going to have to object again unless the commission can
It's
instruct him
noted.
to not refer to it in a mistaken fashion.
We understand specifically it was disorderly conduct, not sexual abuse. She was not convicted of any sexual crime.
That's right.
Okay, got it.
And just to be clear, that is the disagreement here. It was the disagreement at the hearing. It was the basis of the arguments at the hearing. And of course, that's the disagreement here, is whether this is an offense that involved prostitution.
I think the commission's fully aware of the distinction. Why don't we just move on with it?
Okay.
Okay.
Well, but I just want to be clear for
Got it,
council's
got it,
sake and so that.
Thank you, Counsel.
Thank you.
And it's important because that word involved is part of the statute. And as you know, TDLR assumed responsibility for the massage therapy program in 2017 after the legislature directed us to take that. And when we assumed responsibility for that, we were tasked with determining license eligibility, not only of new license applicants, but also renewal applicants as well. And we have that regular process that you're familiar with under Chapter 53 for determining license eligibility, but this is not one of those because we're dealing with Chapter 455 of the massage therapy statutes.
Correct. Let's move on, sir.
Those statutes, through those statutes, the legislature made it clear anyone involved in prostitution or other sex offenses was not to have a massage therapy license. And I've given you the relevant parts of those two statutes there in that handout. The first one is the basic eligibility statute. That's 455, 152A. And there are 4 reasons why a person who was involved in that kind of an offense would not be eligible for license: if the person was convicted, if the person pled nolo contendere, if the person pled guilty, or if the person was placed on deferred adjudication for an offense involving, and it lists those things there as human trafficking, prostitution, or other sexual offenses. That's a broad category there, any sexual offense. And if any one of those apply to a person, of course, that person is not eligible for a license. Now, the second statute is probably more direct on point to what we're dealing with here. That's 455, 251B1. And that requires revocation of an existing license if any one of those same 4 things: plead guilty, plead nolo contendere, found or convicted, or placed on deferred adjudication for, and I'll quote, an offense involving prostitution or another sexual offense, end quote. Now, the language of that second statute especially is very broad to achieve what is clearly the legislature's goal: to keep anyone who is or who has been involved in prostitution or another sexual offense from engaging in massage
I'm going to have to
therapy.
object. This is not part of our hearing, what the legislative goal was, and he's not going to be qualified to testify what the legislators had in mind at that time, and I would object to that.
Okay.
This was part of my argument.
I want us to be sure that when we're comparing the SOA, we understand the distinction that you guys are debating here, right? And I think the commission is fully aware of the distinction. Is that accurate?
Yes.
Okay, so let's just move on. Sharp, you made your point, and let's see if we can get through this, because I don't think we understand what the point is, so we can allow the commission to debate it.
Very well, and that's just what I wanted to stress, is because it's not, the legislature didn't say if you're convicted of, and then list titles of charges. It says if you're convicted of offenses that involve prostitution or another sexual offense. We don't even have any title in the penal code that's another sexual offense.
Okay.
So these are broad categories. And this case is probably a good example of why, because the statutes effectively preclude the use of a plea bargain to circumvent that legislative goal. In this case, the evidence established that Ms. Tang committed the offense of prostitution, even though she wasn't charged for it.
I'm going to have to object to that summation and that conclusion. That's not what the law is, not the record.
And I got your,
Thank you.
and I understand we're not saying she's convicted of that. We understand that, and that's as clear as we got. But let's and understand what your implication is, that it was involving sexual acts. But
Right, and that was the evidence. It was unrefuted.
I'm going to say that one more time so we
Okay.
can move through this. I think we're very aware of it. This hammer is dead. It's in the wood. It's nails in the wood. Let's
Okay,
move on.
well, anyway, that's essentially it, that this was a
Okay.
case that involved prostitution or another sexual offense, if you don't even think it involved prostitution. The ALJ wrote in her analysis that if the legislature wanted to include offenses like this, it could have included language regarding criminal charges involving sexual conduct, but that's exactly the word that the legislature used. So, and I'll get away from that because I know that's become pretty clear, hopefully. Ms. Tang's offense, the disorderly conduct offense, involved prostitution. At the very least, it involved another sexual offense. And so, in order to fulfill what is clearly the legislative goal under these circumstances, I think that we have to reject the ALJ's analysis. I think it was very superficial. And we have to look at this from a practical standpoint. What did the legislature want? This is what they wanted. And for that reason, we would ask that you reject the PFD and issue an order consistent with the exceptions filed by the department.
Okay.
And again, this is new, and if you've got any questions on this one, because it's a little bit different, I'll be glad to answer those.
Any questions for Mr. Sharp?
So being a non-lawyer, I'm curious on this information sheet.
Yes, sir.
Was this what when they went to court, was this the original charge, and then at court it was changed or pled down to disorderly conduct?
Somewhere along the line, because they arrested her for prostitution, according to the evidence admitted at the evidence. So somewhere along the line, they changed it. They entered into a plea agreement, and I think it even says so on the first page there, that the order of deferred adjudication. And they got her to plead to disorderly conduct, and of course, that's a reduced charge. I think it's a Class C misdemeanor as opposed to a Class B, which was prostitution.
Okay. Your answer question? Okay. Any other?
But I would add, that's the factual basis for the charge, because you have to have a factual basis. You
I
can't.
would object to that as a legal conclusion. It's not in the record.
Okay, hang on, Counselor. Let him. You'll get a chance, I promise.
I know, sir. Thank you.
Okay.
That's just a factual basis. You can't just say, are you guilty of something? They say yes, and that's it. You got to have something to back it up. That information is what backs it up. That's the factual basis that supports the charge. And also, the evidence admitted at the hearing said she didn't do anything else that would have constituted another criminal offense, including disorderly conduct.
We'll call you in a little bit, Mr. Bowen, because I'm going to make sure the commissioners are very well with the line we're dicing here. Okay, Counselor, state your name for the record, if you don't
My
mind.
name is Charles.
And who you represent.
Charles Medlin, M-E-D-L-I-N. I represent Ms. Tang, who is the person which is the subject of this hearing. I would first ask you to look at, in contrast, this case with the case that you just heard in front of us, Ms. Martinez.
Stay to the SOA hearing.
Yes.
Okay,
but-
so your SOA hearing, not
Yeah,
her SOA
I
hearing.
understand.
Stay to this one. Okay.
But in this particular case, what happens to Ms. Tang is she's arrested, she's charged, and then eventually she pleads guilty to a Class C, which is punishable only by fine, of disorderly conduct. I think Mr. Sharp and I can agree to that as the facts. I would ask the court to, ask the commission, as you look at this order of deferred adjudication, it says disorderly conduct. There are 15 different ways to do disorderly conduct. None of them are sexual. There's nothing in disorderly conduct which is on its face a sexual offense or anything that's involving sex. In fact, it's the opposite. It is not there. And then if we look at the statute as to what Mr. Sharp is saying, the statute, he's reading it in its most broad potential. And it says the person is convicted of, now we go down to what? Of prostitution or other sexual offense. Enters a plea of nolo contendere or guilty to an offense involving prostitution or another sexual offense. Receives deferred adjudication for an offense involving prostitution or sexual offense. What she was found guilty of, she did a disorderly conduct, and there is no possibility within that statute for there to be anything sexual. And what Counsel Sharp is trying to do is to say that if there's anything that has to do with sexual misconduct, even if it can't be proven, even if the evidence was seized illegally, even if the person is a liar that made the accusation, then that's enough, without any conviction, without any plea to that, for this commission to ban her from having a license for the rest of her life. And that's just not how this statute reads. It's not how it should be interpreted, and it's really unfair if it is. It would be, in my humble opinion, in what I said at our hearing, it would be so broad as to be a violation of the Texas Constitution and so broad as to be a violation of the federal Constitution if you read this section to be having some other act. It would be as if, this is an example.
Hey, okay.
Yes, sir.
I just want to make sure you contain it to the evidence that we have here. I just want to make
Yes,
sure.
sir.
Okay.
And part of the evidence.
And please make sure when you address comments, you address it to the chair, not to the, if you don't mind.
No, I certainly don't mind. Thank you.
Mr. Fedler, I'd like to ask you a question, but I don't want to throw you off your.
No,
your game.
please.
Does Ms. Tang work for herself, or does she run a shop?
She's not working at all right now, and she's trying to work, and she was working in a shop for somebody else. She has the ability to have her own shop, but there is a need for that income, if possible, at this point in their lives, for her and her husband. That's why she's continued to pursue this.
So go ahead and wrap.
Yes, sir. We agree on the facts, we disagree on the interpretation of that law. This is a hypothetical, an example, and it's one that I used at the hearing. It's as if a person is stopped for a DWI, and the officer smells alcohol on their breath, and he gets charged with a DWI. And later down the line, in that DWI prosecution, that person pleads guilty to a disorderly conduct of making a loud noise. And it's as if then the DPS, the Texas Department of Transportation, comes in and says, now we want to revoke your driver's license because the officer said he smelled alcohol on your breath. He never was found guilty of it. He never pled guilty to it. He pled guilty to something that did not involve alcohol. That's identical to the facts we have here. It would be overbroad for the DPS to do it, and I very respectfully urge you would be overbroad for this commission to do it to Ms. Tang.
Okay.
Thank you.
Thank you, Counsel.
And I apologize for,
you're good.
for getting excited.
Good. I get excited too. All right, so, commissioners, any comments or any questions for our attorney?
So counsel, what you're saying, so I can be completely clear before I make a decision, that there's no argument that an undercover officer came in and she solicited sex for money, but she pleaded down to disorderly conduct. Is that correct?
No, I do not accept that as factual.
Okay.
I take that as an accusation. I don't accept that as facts. It was never litigated, and it was never proven. It was never testified to under oath. It was a mere accusation, and I do not agree with that.
Okay. So then my other question then is for you, where it says in this, on page 4 of 7, where it says Montgomery County, Texas, Wee Tang, for a fee, did knowingly offer to engage in sexual conduct with an undercover. Is that a fact?
There is an accusation, a charging instrument, and that is a correct depiction of the charging instrument. Yes, sir.
Okay. You've answered my question. I just wanted to make sure that I'm clear in my head before I make a decision.
Thank you, sir.
Thank you.
One or two more questions. Mr.
Yes, sir.
So, Ms. Tang, can she go back to work at the same facility or shop?
No, it wouldn't be. It would be a completely different facility and shop. It would be a completely different circumstance. And she's already picked out a place that will allow her, and it's reputable, it has no history.
Excuse me, I just want to make, this is Brad Bowman, I just want to make sure we're talking about things that are on the record or that would
I
discuss.
understand that, but, and the only reason I'm asking is, so there's a bigger, in my mind, in my very small, feeble mind, there's a bigger issue at play here. I want to make sure that this isn't a place that does condone any type of behavior like this, and there's a human trafficking aspect to it, which in my mind is very important. So I want to know, is this something that was condoned by the facility, or is this something that has been alleged on Ms. Tang's part as an individual? And was she forced to do something? So I'm trying to get my head around some things that aren't here in front of me, but I need to be satisfied to whatever extent I can that that there's an undercover victim. If Ms. Tang's a victim, I'm trying to get my head around a couple of things that may not be in black and white in front of me.
Well, I wasn't the attorney for that case when it was being litigated in Montgomery County. And so there are some things that I just don't know the answer to. What I do know is that Ms. Tang has no criminal history before, she has no criminal history after, and she has a long-term marriage that's committed, that her husband's always with her, and I have no doubt that whatever that episode was is long gone in the rearview mirror and is not something that's ever going to be in Ms. Tang's life again.
And again, I'm sorry, this is Brad Bowman, I just want to make sure that we're, in answering the Commissioner's questions, that we're addressing things that are actually in the record.
So
They were, except for the long-term marriage. That wasn't in the record. As I understood it, that it was actually a fairly recent marriage.
It may be, but he was,
Is this in the record?
No.
I don't think so.
Okay,
I don't
then let's
think so.
not worry
No.
about it. Okay.
Vice Chairman Butler, just to respond to your question, there's nothing in the PFD that would prevent Ms. Tang from returning to the place that she was previously employed. The license would allow her to work in any licensed establishment.
All right. Any other questions?
No,
Hang on.
Mr. Sharp, so the disorderly conduct, what she was convicted of, what are those elements? Is that a list that you meet one of the criteria on the list and you get charged with and convicted of disorderly conduct, or did she meet the elements of disorderly conduct? I'm trying to see I'm trying to see, because she pled guilty to disorderly conduct, what were the elements that she met for this charge?
Well, and that's where it gets interesting, because in Section 4201 of the Penal Code that specifies what disorderly conduct is, there's nothing in there, as counsel said, about that type of sexual, there's some lewdness and things like that, but nothing that what we're dealing with here. It has something altogether different. Nothing that she did that day, according to the evidence admitted at the hearing, constituted any offense other than prostitution. And prostitution, the elements are different than disorderly conduct. What she did doesn't satisfy any of the elements or doesn't establish any of the elements of disorderly conduct. It was simply a plea agreement.
Commissioners, I want to caution, right, the statute is the statute. We are not legislators, so I want you guys to understand as clearly as that. Also, I need a motion or any other questions.
So, Mr. Chairman, if we adopt the PFD as recommended, Ms. Tang gets to keep her license.
That is correct. We'll go in line with the ALJ.
Okay, so this may be an instance where we're not happy with any decision. Is this a possibility of a probated licensure, Mr. Bowman?
Commissioner Brad
The way
Bowman.
we've done in the past?
If you were to disagree with the legal conclusions of the judge and find that this criminal offense is a basis for suspension, or that you could do a probated suspension of the license. I think that's maybe what you're getting at there, and we might need to talk about what your rationale for that is in terms of the statutes that are involved here, or
Can you help me artfully craft something there? I think there was a sexual component to this underlying offense or allegation, but Ms. Tang works for herself. I'm understanding that she's free to go wherever she wants to go.
well, you have the prosecutor's argument that involving prostitution kind of means you can bring in these circumstances from the charging instrument to inform that, although she was not, what she was ultimately, what was adjudicated was a disorderly conduct offense.
So would I have to take issue with a particular finding? And that would be
Give me
finding,
just a second, let me.
finding number 7?
It looks like there are not any findings of fact at issue.
The
I think
conclusion of-
this is the, let's see.
I'm sorry. I was looking at the conclusions.
Conclusions of, well, I'm sorry, if you give me just a second, I think it sounds like you are disagreeing with conclusions of law 10, 11, and 12, which concern the interpretation of the massage therapy statute, and as well as, I'm sorry, not 11. 11 has to do with Chapter 53, and conclusion of law 12. So it would be 10 and 12. 12 deals with Chapter 51 of the Occupations Code, the Commission statute, which requires honesty, trustworthiness, and integrity for eligibility for a license.
So what I'm struggling with is, what we have is what she pled guilty to, which precludes the sexual nature of the charging instrument. But the flip side is, we want to make sure that our licensees are not engaging in this type of behavior. And so we're limited to some extent by what the prosecutor did in Montgomery County, but we want to make sure from our perspective that the public policy,
No, sir, go ahead, you just have a seat. Just
Okay, thank you.
that the public policy issue or the licensure issue that we adjudicate lets them know the seriousness with which we take these cases. So I'm trying to do the best of both.
Well, to accomplish what I think you were seeking to do, which was a probated suspension of the license, which would allow her to continue working, but with and you need to pick a term, would it be 1 year, and following reasonable terms and conditions, complying with the department's laws and rules, and not committing any further criminal offenses, and then on the basis of those two conclusions of law, that you disagree with the judge's rationale
That's what you're trying
for
to-
that.
Yes.
So probationary.
Yes.
So I think I'm ready to make a motion, Mr. Chair.
Go ahead.
So-
Any other comments? Because you introduced a lot of thoughts.
No, that's what,
Okay.
I
Go
agree
ahead.
with Commissioner Butler on getting a little clarification like we did.
Go ahead, Commissioner.
So I would like to make a motion that we do not accept the PFD as written. And I would like to take issue with conclusion of law number 9.
10 and 12, I believe.
Forgive me, I'll rescind that conclusion of law number 10 and 12. And I would further motion that we revoke the licensee's massage license, but suspend that revocation for a period of 1 year, or probate,
probate suspension.
Whichever is a more artful.
Well, and I'm sorry,
That's okay.
there's two different sanctions. There's revocation of the license and suspension.
Okay.
So if you're suspending the license and probating that, it would just be a suspension of the license probated
So
for that period
I'll
of time.
rescind the revocation, suspend the license, and probate it for a period of 1 year.
And it was just brought up, perhaps 2 years because of the 2-year license.
2-year
Renewal.
licensure?
It's
Okay,
it's a
perfect.
2-year
Thank you,
license.
thank you. Thank you for that. I think that's my motion, Mr. Chair. Is that clear, or do I need to?
Is Commissioner clear on this? Basically allowing the licensee to
Licensee
work
to
under
work
conditional
under
probation
probated
for 2
suspension
years.
for
Is
2
that-
years.
But you're disagreeing with the ALJ on the, or you're taking issue. And
Second.
with 11 and 10, is that accurate? Or 11, 12, 10 and 12?
10 and 12.
10 and 12.
Correct, okay.
I
Is there-
second that.
Second the motion? All right, all in favor? Say aye.
Aye.
Opposed? All right, motion carries.
Thank you all for your time, gentlemen. Ma'am. Thank you all.
You understand, if you want to appeal the process or anything, you still have, and get with our staff on that,
Yes, sir.
correct?
Thank you.
Thank you, Counselor. Thank you for your patience. All right, next case, number 4 on the docket is James Leo Farmer. Mr. Sharp. Is anybody here for Mr. Farmer? Thank you. Okay. Go ahead, Mr. Sharp.
I hope I haven't disgraced my family, but I don't have a handout for this one.
Mr. Sharp. Actually, Mr. Sharp, if you don't mind, Commissioners, can we take like a 10-minute break, if that's possible? Because I know it's been a while. All right, so let's take a 10-minute break. You don't mind?
No, not at all.
Okay. Now 10:26. James E. Leo Farmer. We'll make sure there's nobody representing Mr. Farmer here. All right, Mr. Sharp, go ahead.
Yes, sir. James Leo Farmer Jr., that's a respondent in this case. The administrative law judge recommends that you deny his application to renew his residential wireman electrician license and that you revoke that license. The department issued that residential wireman electrician license to Mr. Farmer in 2007. In 2018, he pled guilty to theft of metal, which included copper, having a value of less than $20,000. The court placed him on community supervision, deferred adjudication for a period of 5 years. Now, according to the police report that was admitted into evidence, Mr. Farmer stole copper wire, materials, and tools having a combined value of over $32,000 over a period of time from his employer. Many of those thefts were recorded on surveillance equipment, and he sold some of that copper as metal salvage and used other materials in construction projects that his employer was not involved in. He was 38 years old when he committed those thefts. The ALJ found that Mr. Farmer's age at the time of the thefts was significant, as well as the fact that he committed the offenses in the course of his licensed occupation. The offenses were recently relevant, and Mr. Farmer presented no evidence of rehabilitation. The ALJ concluded that more time would be needed for Mr. Farmer to establish a record of good conduct to show that he can be trusted. The ALJ recommends that you deny the application to renew his license and that you revoke Mr. Farmer's residential wireman electrician license. The department asks that you adopt the proposal for decision.
Mr. Chairman,
Yes, sir.
I recommend a move, approval of the RFP, or the, I'm thinking, PFD.
Okay, we got a motion. Any comments? Any comments or questions? Mr. Sharp? Okay. Second, we got a motion. Second, all in favor, say aye.
Aye.
Opposed? Motion carries. Okay, Eberhart Electric. Mr. Servant, how are you, sir?
Good, how are y'all? Good morning, Commissioners. My name is John Madlock. I'm a Senior Prosecutor with the Enforcement Division. The facts of this case are fairly straightforward. The respondent, Bryanson Eberhart, is licensed by the department as an apprentice electrician, but he does not hold an electrical contractor license. On June of 2018, Mr. Eberhart placed an advertisement on Craigslist offering to perform electrical services himself. The department took this advertisement and used it to contact Mr. Eberhart as part of a sting operation utilized by the department to help root out and stop under-licensed and unlicensed activity in the electrical field. On or about June 6th of 2018, Mr. Eberhart was contacted by the undercover department investigators and asked him to come to the sting location in Houston. Mr. Eberhart visited the sting location and submitted a bid to the department in the amount of $2,050 for electrical work. Based on the evidence submitted and the testimony provided, including the respondent's own admission to providing or offering to provide the electrical work, the ALJ concluded that Mr. Eberhart had committed the violation for offering to perform electrical work without having the required electrical contractor license. The ALJ recommended a penalty of $1,000 for this violation. The department would ask that you accept this PFD, and I am available for any questions.
Is there anybody here to represent Mr. Eberhart? Okay. All right. Any questions? Okay. I entertain a motion.
I'll make a motion to accept the PFD as written.
Second.
All in favor?
Aye.
Motion carries. All right. Mr. Shirk, how are you this morning?
I'm doing very well, thank you.
Good. Allied Collusion Center? Anybody here?
Chairman Figueroa, members of the commission, opposing counsel broke down, his car broke down on the way here from Houston, so I'm asking that this case be continued until your next commission hearing. Mr. Bruce is also opposing counsel in the Eurostar Records case, number 8 on your docket. I'm also requesting that the case be continued until the next hearing because of problems.
Thank you, Mr. Shirk. Hope he's all right. Is there any motion?
Yeah, make a motion for a continuance.
Second?
Second.
All in favor, say aye.
Aye.
That was quick, Mr. Shirk.
I'll have one more.
All right, we're on with blue collar towing. Is there anybody here with blue collar? Okay.
Commissioners, this is a proposal for decision that was issued by the administrative law judge. On July 26, 2019, staff did not file exceptions to this case. This case arises out of a non-consent tow that occurred in the city of Seguin. And as you know, cities can have their own local ordinances about charges for non-consent tows. The city of Seguin has a number of charges that can be charged when there's a non-consent tow, including winching fees, extra labor fee, dolly, rollback, things like that. Those fees, in order to be charged, however, must be pre-approved. The services must be deemed necessary by law enforcement at the scene. The question before the administrative law judge was whether or not the tow operator had received the approval of law enforcement before performing those services and charging those fees. The administrative law judge found, as a matter of fact, that staff failed to meet its burden, proving those charges had not been approved. That is, that the charges were approved and they were appropriately charged. The administrative law judge did find that a mileage fee charged by a respondent of $30 was in excess of that permitted by the local ordinance. The recommendation of the administrative law judge, though finding an overcharge, was not to impose an administrative penalty, but simply to order the refund of that $30. Staff has no objection to the PFD being adopted as written.
Okay. Any questions? Mr. Shirk? Okay.
Make a motion to approve the PFD as written.
Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed?
Thank you.
Thank you, Mr. Shirk. All right, number 9, Galarcy, right, Electric, and GNNRA Electric LC. Is there anybody, I got one, Paul?
Yeah, he is here. I know he stepped out. I don't know, he hasn't made it back in yet, so.
Okay. Mr. Bowman, can we give him some time before we could do that? You don't mind?
Yes, sir, that's within your.
Okay, so we're gonna, if you don't mind, we'll give him
Don't
some
mind at all.
time. While we're waiting on him, if you let us know when he gets back in, as soon as he gets back, we're gonna go ahead, that's our last contested case. So let's go back into motions for rehearing, okay? If you're here today for a motion for rehearing, you wish to speak to the commission, we'll call you up when you announce your case. We'll hear from the general counsel first, and then you have an opportunity to speak. Make sure you fill out the public comment form if you want to speak, and make sure you give it to Ms. Fletcher. Make sure you state your name in the microphone and who you represent. This is a motion for rehearing, which means there has already been a decision made in your case, so we're not here to re-argue the case. I'll say again, we're not here to re-argue that case. This is an opportunity for you to tell us how we made an error in entertaining the decision against you, and you'll be limited to speaking on those issues that are raised for the motion for rehearing only, okay? So we're not here to relitigate the case. Just want to make sure that's the case. How are you, Counselor?
Doing well, Chairman. Thank you very much. Doug Jennings, Assistant General Counsel for the Department.
And Mr. Walnoskos, is that right? Is that the
I
pronunciation?
believe we have him here today.
Okay. How do you pronounce your name, sir?
Winoskis.
Winoskos. I apologize for butchering that. Winoskos, did you hear what I had said?
Yes, sir.
Okay, we're not here to relitigate the case, just for the motion and why we want to rehear, okay?
Yes, sir.
We'll get to you in a minute. We're going to have Counselor. All right?
Thank you, Chairman. This matter resulted from a commission order from your last meeting in which the commission denied the respondent's application for an electrical apprentice license based on his criminal history. In the commission's order dated August 6th, the commission denied the respondent's application to become a licensed electrical apprentice. The commission adopted a proposal for decision that found the following. On November 5th, 2015, the respondent pleaded no contest to the offense of sexual assault of a child. The court deferred adjudication of the offense and placed respondent on community supervision until November 2020. The offense in question took place on July 7th of 2014 when the respondent had sex with a 15-year-old girl. He was 23 years old at the time of the offense. Respondent's motion for rehearing contests this commission's finding that he's a threat to public safety. He states that he is enrolled in a sex offender treatment program and that his employer, probation officer, and counselor have deemed him trustworthy. He also stated in his motion that he works hard to support his fiancée and 3-year-old daughter. We don't believe that the motion for rehearing states any error made by the commission, so we therefore recommend denial of the motion. Thank you.
Any questions for Counselor? Okay. You want to make sure, again, it's going to be tempting, but we're not here to litigate a case. You just got to tell us where we might have gone wrong in processing this case, okay? And that you would want to be hearing.
I'm just trying to represent myself.
State your name if you don't mind.
My name's Nathan Winoskis, and I'm representing myself. All I can ask is for a probation period, you know. That's all I want to ask for, is to be able to be deemed trustworthy.
Okay.
Because I need to support my family.
Okay.
And that's all I have to say.
Okay. All right, commissioners? Any questions? I'll give you a minute.
And can I say something else?
Sure, go ahead.
In the beginning of all of this, I didn't have the knowledge of what I needed to bring to the ALJ, I guess, and wasn't able to submit, but from something from my probation officer, because I didn't have the knowledge of what all I needed to bring. And I know I can't submit it, but I have more documents here, but I mean, from everybody that I've worked with that knows me as a person,
Okay.
and not from what I've done, so.
Okay, we'll give him a time. Just a quick question. You were notified of the process, is that accurate? How were you notified?
It was by phone call, I believe.
Okay. And you were at the ALJ hearing, correct?
Mm-hmm.
Okay.
If I may, Chairman, the respondent received a notice of alleged violation and a notice of hearing. So he was served. So he
Right.
may have also communicated with staff via telephone, but was certainly served.
Okay. Okay. Commissioners? I'm gonna give you a little latitude here. So, your questions?
Commissioners, this is Brian Francis. Just remember that denial of the motion for rehearing just moves the respondent down
To the
his
next.
other appeal rights. This is not, if you deny here, it doesn't end his road and his opportunity. It'll just give him the opportunity to go to district court. So there's, you know,
Right. And again, the lane is very narrow. Was the hearing in any way misapplied?
Yeah,
Or do
this
we
is-
miss? Yes, sir.
I'm
Go
sorry
ahead.
to interrupt, Mr.
No,
Chairman.
no, go ahead.
Just to add on to that, the standard is, was there error in the process? It's an opportunity for the respondent to point out any errors that may have happened. And obviously, as Doug has outlined, we don't.
You
see any-
understand what we're looking
And-
at, right? Our lane is very narrow. Okay.
And with the back in August, that hearing, as he deemed earlier, that we only had a allotted amount of time frame, that I was notified of the actual date of that hearing of last month. And I wasn't able to take time off and come to that hearing because it was maybe like a week prior to that. And with my employment, I need at least 2 to 3 weeks for that to be processed, so I could have that time off for
Okay.
vacation time, so.
Okay. Commissioners?
And Chairman, if I may, if enforcement has a timeline about the amount of time that was provided to the respondent for the hearing, I don't have that document with me, but I have a strong feeling it's not simply a week's notice.
Okay. Again, we just want to stay in our lane. I want to make sure we don't
Right.
gravitate our lane. As difficult as it can be. All right, commissioners.
Okay. Okay.
Any questions? No questions. All right, I'll entertain a motion.
I'll make a motion that we deny the notice or the request for a rehearing.
Is there a second?
Second.
All in favor? Say aye. Opposed? Sir, again, much to Mr. Francis's comment, this isn't the end of the line, right? right? We had a lane that we had to stay in. I understand. Our job is not to deny you opportunity, right? But there are consequences. But make sure you get with our staff. Make sure you understand what your rights are in the process that you, I'm sorry this whole process happened. You brought us here, but whatever the case may be, make sure you follow up with our staff. We want to make sure you understand fully your rights in this whole process, okay? And they're amazing people. All right, thank you for your time today. Okay, Willie Allen Howard, next case number 2.
Thank you, Chairman. Doug Jennings, Assistant General Counsel for the Department. This matter resulted from a default order in which the Department assessed administrative penalties against the Respondent totaling $4,000 based on the Respondent allegedly performing electrical work without holding an electrical contractor license. This case arose from a complaint that the Respondent had not completed electrical work he was hired to perform, and upon further investigation, the Department determined that Respondent had been performing electrical work without possessing the required electrical contractor license. The Respondent is a licensed electrical journeyman. In his motion for rehearing, the Respondent states that he did not perform the work in question without a electrical contractor license. He states that an electrical contractor by the name of Freddie America pulled the permit and that he performed the electrical work under the contractor. And the facts don't support the Respondent's theory. In a call to the Department investigator on May 25th of 2018, the Respondent admitted that he performed the work in question and that he paid $500 to an employee from an electrical contractor to pull the permit. So we believe even though this is a default, looking behind it to make sure that the facts support the finding in the case, we believe that they do. And we believe that the case against the Respondent seems well supported by the evidence, and therefore we would recommend denial.
Any questions for Counselor?
I recommend denial of rehearing.
Second? All in favor, say aye.
Aye.
Opposed? All right, Mr. Stanley, Glenn Stanley. Anybody here, Mr. Stanley? Okay.
Thank you, Chairman. This matter resulted from a default order in which the Department assessed administrative penalties against the Respondent in the amount of $3,500 based on the Respondent's alleged offer to perform electrical work without being licensed as a contractor. As we provided some meetings ago, Office of General Counsel said that we would not be bringing motions to the Commission that did not state any claim of error. Must admit this one slipped through our radar. There is no claim of error here, just some personal attacks on the complainant, and I won't elaborate on those, so I would just recommend denial.
Good. Thank you, Counselor. Any comment, questions?
I'll make a motion to accept that.
A second?
Second.
All in favor?
Aye.
Opposed? All right, we're going to jump back, if
Thank
you
you.
don't mind. Thank you, Counselor.
Good job, Gus.
Galars?
Yes, sir.
Okay, you filled out a form, correct?
Yes, sir.
Okay, now, want to make sure you understand that we got to contain our discussion to the SOA hearing.
Do my best, sir.
Okay, so it's important that it's real.
I do
prosecutors.
comprehend.
Okay, I
I
got your
was
form here, so we'll go there.
Good morning, again, Commissioners. Again, my name is John Medlock, Senior Prosecutor with the Enforcement Division. This case was tried before the State Office of Administrative Hearings on March 5th of 2019 by Prosecutor Robin Glassner. Ms. Glassner has accepted a position with the Attorney General's Office, which is why I'm presenting this case before you today. The ALJ recommended a $12,000 penalty for engaging in electrical contracting without holding the appropriate license. The undisputed facts of this case are that on 3 separate occasions, Mr. Glarce contracted for the installation of solar panels with 3 different homeowners, all of whom were retired U.S. Army veterans. Mr. Glarce was not licensed by the Department in any capacity, but he secured the contract for installation of these systems, which range from $15,000 to over $40,000. As part of the contract, Mr. Glarce was supposed to submit municipal electrical rebates, but he never did. After each of these systems were installed, each of the customers had problems with the systems not working properly. Mr. Glarce did little in the way to help correct these issues that the solar systems were experiencing. Rather, in 2 instances, Mr. Glarce offered to perform non-electrical work to compensate them for the unhonored portion of the municipal rebates. However, there was no evidence that Mr. Glarce did in fact return any of the money to these 2 individuals. The ALJ concluded that Mr. Glarce engaged in electrical contracting when he facilitated the contract for installation of the solar panels and that he was in the business of designing, installing, erecting, repairing, or altering electrical wires or conductors to be used for power, including installation or repair of electrical machinery, the apparatus, or systems used for electrical power. As such, the ALJ found that Mr. Galarcier was in violation of offering to perform in 3 separate instances, that each of these violations were serious due to large amounts of money that each of the individuals had to spend both for the installation and subsequent repairs of the systems, and that there was little evidence that Mr. Galarcier made any efforts to correct these systems after installations. The ALJ recommended a penalty of $12,000. The department would recommend that you adopt this PFD, and I'm available for any questions.
Are there any questions? Mr. Medlock? Okay, state your name and your business, if you don't mind, in the microphone, please.
Oh, my name is Paul Galarcy. The business at the time, because I haven't been conducting any business since this incident. First of all, I want to thank the consul for dressing up really nicely today on my birthday. Appreciate that. Also, I really appreciate the prayer you guys made. I strongly believe in that, because when I started this, it started with a prayer with the Roysters and the Joneses. Also, at the hearing, so we can go back exactly to the hearing, I do want to say I really felt like I was completely surprised, because at the hearing I thought I'd be heard, but it was just nothing but objections being flown left and right. So I'll stick to what I was able to get through at the time. All 3 clients did state that I assisted them, or tried to help them, all the way through to 1.5 years. So that statement that I did little to help them, completely false. And I have it all on record. A whole 1.5 years without getting paid. Also, I never offered electrical work because I'm not an electrician. I wouldn't know where to put one cable with the other. What I did was I facilitated these folks with a solar company named Tesla Solar, ran by Anthony Regino. All this is in the hearing, by the way, who unfortunately did not comply with the agreement. He was paid in full and in cash directly by the clients. They didn't pay me, by the way, directly. They paid the client directly. On one of the cases, I was just a sales rep. Just the guy that comes in here, does the presentation, sign here. That's the guy who I was. The company was Tesla Solar. And all this was admitted by the customer, the client, the homeowner. And they all said that I never once offered electrical. Okay. Now, on the 2 other occasions, the other one was basically, it was a venture that the Roysters and I decided to do together. It was supposed to be a rescue mission, and I do mention this at the hearing. And it turned out to be an unfortunate situation for all of us. They should have never gone through this. What they went through, they should have just got their system right away turned on and moved on, and they would have got tons of marketing from them. I love assisting and helping veterans. That's one of my biggest markets. This has been the only time I've ever had any issues, and it's unfortunate. It was through Tesla Solar and Anthony Regino ever since then. Never messed with them again, never had any problems. As a matter of fact, if you look me up, you'll find tons of great reviews on me, assisting people within the industry and also with installation. I've also been for 9 seasons. I've been an active member of the community, a volunteer community, giving.
And I'm sorry,
towards the youth.
is this all in the record?
Unfortunately, I wasn't the attorney at the hearing, so
And yes, sir,
I can't verify.
Sir, hang on, just give a second.
I just want to make sure that it's testimony that was in the hearing, and it wasn't clear, but.
I'm looking for it here. I'm trying to find it.
It was a very long hearing.
Okay, I got your comments. Go ahead, sir.
Mm-hmm. And they're very aware of my intent. So there was no criminal intent at all to try to take advantage of them. On the contrary, I assisted them, I helped them, I was hands-on with whatever I can do that has nothing to do with electrical. The electrical part of it, they paid directly to Tesla Solar. They didn't pay me. And then on top of that, I never even asked them for the balance of the job because of all the troubles I went through. Never once. I understood that they had a really bad turnaround on that specific part of it, because everything else they got whole 100-fold and then some. I gave them additional things like gutters. Had nothing to do with solar. I gave them.
Is this in the record?
Oh, yes.
The ALJ does make mention that he did make offers of performing non-electrical work to some of these consumers.
Okay.
And they were taken care of and done, and they were super happy. It was. I was the one that told them to direct their complaints and their concerns towards TDLR. I walked them to the CPS, which is the utility company here, the electrical utility company here, to state their complaint, see what was going on, why their solar wasn't being installed. Because I'm not an electrician, so I can't submit the interconnection applications, and they're very aware of this, that Mr. Anthony Regino had delivered. So, long story short, sir, I'm basically the guy that sold them the system and tell them about the system, but the electrical work, I never offered electrical because I'm not an electrician, so I don't even understand why I'm here. I did nothing wrong. As a matter of fact, the person that did this, their license was on the TDLR site at the time as a journeyman, and he's working with a master electrician, and all these are requirements to install solar. He's Tesla Solar, and that's why we went with him, because of the reputation he had at the time.
Is that accurate?
That I
Is it
can't
the record?
testify to, but there is Tesla Solar that some contracts were going through the PFD and some of the exhibits that were introduced. There are contracts with Tesla, but at the same time, there are also contracts with the company that he created and checks that were paid directly to the company that he created. And as a matter of
Objection.
fact,
The checks.
Hold
Okay.
your.
and as a matter of fact, it's there's a specific line in there when it goes to the offering aspect, which is what the judge found that he did. He offered the electrical work. It says the evidence shows that Mr. Wilson, who was one of the complainants in this case, was initially skeptical, was persuaded to enter into the contract for installation of solar panels because of the respondent's representations, not of anybody else's. And again, there are several instances in here which it says that the contracts that were signed were on company letterhead of companies that he created, not of anybody else's.
I did create a company, and that was after, it's a timeline thing. So this was in 2015. If you look at the TDLR sites, everything that they're saying should be required says effective September 1st, 2017. Okay? And I think what's really happening is that the guy that's responsible for not doing the work for these people is nowhere to be found. Okay? They can't find him. And the only one that's showing up, yes, absolutely.
Mr. Galarcy?
Yes, sir, Galarcy.
Okay, Mr. Galarcy.
Mhm.
You work for Green Energy Efficiency?
Yes, sir. I was their sales representative
So
for
when-
NES.
When Mr. Wilson saw the bad reviews and canceled the check, you went back to him in another form.
Correct.
So
Well,
he said, Green Energy is not good, and then all of a sudden you pop back up in a different company, different entity. Say, I know they're not good, but I'm great.
Close.
Okay.
At that point, I didn't have my company, okay? This was prior to me having my own company. Because of all the mess that was going on, that's why I opened up my own company, to make sure it was getting done right, okay? So Green Energy Efficiency had this Anthony Regino, Tesla Solar, installing all the solar for them.
So the mess has followed you now.
Yeah, I ended up in the crossfire of it all. But I'm happy to be the one to be here to present it to you guys, because for many reasons. This guy has taken advantage of many people, and I have a very clean record. And not only that, I have a great reputation within the industry. So if anybody could come and assist these folks, it could be me. And that's what I offered them. It was my idea to go to TDLR. It was my idea to go to CPS Energy. I even went to the district attorney's office when we found out of what was going on. I took these initiatives. I also submitted a lot of this stuff that you see here in evidence against me. I submitted this information to TDLR complaining against Anthony Regino, that they took it upon themselves to use this evidence to try to come against me. And I believe it's because I'm the only one that's showing up. And I'm the only one that's presented themselves here, and my name is on this stuff. Okay, and I understand that. I don't mind. I'm still helping the Roysters today, and the Joneses, and this gentleman you mentioned, you know, who is also a veteran, but by being here today, so that I can shed light onto what's really happening. Now, I do understand that by them getting together makes them really strong, and I think someone got maybe a little bit nervous, so they put all their efforts together, okay, to come after whoever they could, and it's unfortunate, because these are very talented people, and it's unfortunate that they're going after somebody who's completely innocent, that did their work, never offered electrical or got paid for electrical. They never paid me for that electrical stuff. What they paid me for was the attic packages, okay? And it got done immediately, and they can testify to this. Unfortunately, I don't know how it all got spun around to try to come after me, and I think it's just because they couldn't get in touch with Anthony, and I understand that, but I'm here today. And what I'm trying to tell you is this. I did not offer them any electrical work, and they can testify to this, and they did testify to this. They said he never mentioned that he was doing electrical. Instead, what I did is I took upon my responsibility to help them with the unfortunate matter that what they had at hand, which was working with Anthony Regino, Tesla Solar, who did not install the system properly onto their home. Installed it, but not properly. And we didn't learn this till afterwards. Solar takes so long. Today, we could have a contract. It takes, and at the time, it was taking CPS Energy 6 months just to get an approval. So as you can see, during this time, customers and homeowners get really antsy and very upset. Things happen, and unfortunately, I believe Anthony Regino got caught up in a money situation, and instead of using their money, and this was, you know, at the hearing, instead of using their money to take care of their work professionally, he must have used it for something else. I presented this complaint to TDLR since then, and I still haven't heard anything from them about that.
Mr. Galarski,
Yes, sir.
sometimes the guy that shows up is the guy that's left holding the bag.
Uh-huh.
And unfortunately, that's the position you find yourself in. However you got here, you know, it's a long, convoluted trip, but you're here. And you represented yourself as Generate Electric. And so that may be why you're here. Be careful moving forward. It's obvious you're a salesman, and you've done a good job representing yourself here
Thank you.
today. But just be careful moving forward. You don't want to be back here. You don't want to be before us again. I hope you understand what brought you here now, right? And hopefully you've learned a lot through this process. And I don't know what's going to happen here, but just be careful in the
Well, I
future.
have.
Just be careful.
I have, thank you.
Is there anything else you want us to know?
If it's gonna take your time, no. There's so much more I'd like to share.
I bet there's a lot.
Yeah, but I think
this is like
this
an
is-
onion, right? The more you
You unpeel it, there's a lot to it, but I think,
want to cry. Yeah.
but I think you see the big picture, I think, with what's happened.
Yeah,
Mhm.
definitely.
Any other questions?
I have one.
Yes, ma'am.
Does Anthony Regino own Tesla Solar?
Yes, ma'am, he's the owner of Tesla
And
Solar, yes,
he
ma'am.
cannot be found?
He's turned out to be pretty slippery. A slippery character.
Is he licensed?
I don't have that information.
Commissioners-
No, his license
Commissioners-
has been revoked.
Commissioners Brian Francis, let's stray away from that just in case there may be an
Contingency,
action that
yeah,
comes.
exactly,
We
that's
want to
right.
make sure
Yeah.
that we're not.
If he is, we need
talking about
to
that
stay
for you.
this.
Mr. Chairman, I got a question. My question is maybe more toward the administrative side of TDLR. Whenever somebody fills out like a DBA for, say, Generate Electric, do we prove that they're an electrician if they have electric in the title, or are we? You understand what I'm trying to ask? How, like, can I open Ray Callis Electric as a physician and just go ahead and get approval for that? I know that, I know this is kind of off the record, but I'm trying to come up with a.
You could, because it's by county. The county's not going to come back and look at our licensing database to see if they've confirmed that or have the background. But the moment that you offer to do work, to do electrical work that's covered, or you perform work, then you've crossed the line. You're holding yourself out as.
Right, and that's what I think happened here, and so that's why I'm just trying to come up with an idea for maybe future
Sure.
we can discuss about that.
Absolutely.
Because my problem is that if he came to my house, I would think he's an electrician. I mean, whenever I read he's Generate Electric, I mean, he's definitely not a veterinarian. I mean, my point is that we got to come up with some
That's a
type
good
of
point.
answer.
And Commissioner
Your Honor,
Callis?
May I clarify a few things?
Just saying, let's go in order. Go ahead. I'll let you.
To your point, the ALJ kind of addressed that. and this is quoting from the PFD, it said, by displaying electric on his contracts, and then the name Generate Electric, the general contractor responded, advertised that he or Generate Electric was a contractor or, could be doing that kind of work. So it's the implication of
Yeah,
it.
that was my concern.
Mr. Larson?
Yes, on the LLC, when I filed, it asks you what type of work you're gonna be doing, and in no way, shape, or form does it say electrical on there, to be clear.
Is
So
that in the
generated
file?
electric.
That is not, to my
I
record.
can't look at that, sir. I know we can't consider
Well,
it.
I'm just
to be-
saying, you know, you
I know.
can see it. There's no reason for me to tell you a false statement. I've been truthful from the very beginning, and that's the key to this, right? So that's number one. Two, so at some point, I did want to become a full-blown solar company, and that's why the play on words Generate Electric, okay, which is supposed to mean green energy, renewable now forever. That's the Generate is really an infinity sign. But anyways, that was supposed to happen when these deals came in through cleanly, and then you can start purchasing and doing all the things you got to do. It takes money, guys, to get licenses and things like that, right? Well, unfortunately, we never got to that part. But that was at some point, the intention to build something great and new, and I never got the opportunity to do it because of the criminal actions of Anthony Regino through Tesla Solar. Yes, sir. Hopefully that clears it a little more.
Yeah.
Mr. Larson. Any other comments or questions?
I have a question. So, Generate Electric, that's now defunct. It's just, you discontinued.
To be clear, I never bankrupted because when you bankrupt it like that, you look guilty. I left it open. I haven't conducted any business. I left it open so that you can see what's happened to me as a citizen, somebody trying to build a business, you know what I mean? And I actually went into debt because of it, because of the bank, because of, everything that happened.
So what are you doing now for work?
I work for Pure Energy.
So are you doing
which
the
is
same thing now
It's
that you did?
yeah, I've been a solar guy since I came here to San Antonio. And I love it. I serve my community. I help a lot of people. I help CPS Energy with their grid in San Antonio. So, and I have great reviews. Like I said, I stand by that. If you look me up, you'll see nothing but great reviews on me, on what I do.
So basically a new company, and then you
It's
create a
not
new
my
company to do the same. Is it your company?
No, sir. So,
You
to,
work for some.
to shed some more light. So, I became
This
an
is
expert.
probably not in the record.
It is on the
Okay,
record,
yeah.
sir. It is on the record. Because
I
I stated.
guess I'm trying to see, because I guess the first time you created a new company for you to go over, and
The
it
first
kind
thing.
of seems like you're creating companies and jumping over.
Okay,
to
so-
kind of get away from the past.
On the contrary, I've never shut it down. It's right there, open to
Right,
see,
right,
so
so
you can
that's
see
my-
what
that was
happened
my
to that.
question.
And
Okay.
I've never opened up a new company ever since then because of it.
Okay.
On the contrary, I would like to clear this, right, so that I can function under that name, Generate Electric, and doing it the way TDLR requires it and everything. Because this was back in 2015. All this new stuff came afterwards, through CPS and TDLR. So I'm more than willing to comply, obviously, but I left it open for you to see. Never again did I open a new company. Instead, I work for other solar companies that have all the requirements, 5-star companies with Better Business Bureau on the list with CPS, compliant with TDLR. Yes, sir.
Okay, I just want to say, I want to give the commissioners time. Okay, that's what I want to. So I know we're trying. Look, we want to get this right. I appreciate you being here. Okay, appreciate your time. You're a citizen of the state. We appreciate, but our job is to stay within our lane, which is to understand what the ALJ issued and to make sure that we cover the facts. We're not really litigating. We're not trying to introduce any more evidence to this case. Just want you to make us understand, because it can get confusing, and it is confusing. But I want to make sure that we're here for the state and the people of the state to make sure that they can get the best service they can.
Absolutely.
Okay. Is there any more comments or questions for Mr. Medlock?
Again, not being at the hearing, I can just rely on what the ALJ said, but
We're all
essentially,
the same boat. We're
yeah,
all the same
essentially, from what it looks like, based on their statement, is he made multiple representations and multiple offers to these 3 different individuals or 3 different homeowners that he could perform the solar electric, and that is the basis. It's the offering, not necessarily the performance. The offering is what triggered the violations in this case.
Okay. Any other comments? Okay. Mr. Bowman, do you have any comments?
No, sir, unless the commission has any questions.
All right. I'll entertain a motion.
Make a motion to file a PDF.
All right. There's been a motion, second. All in favor, say aye.
Aye.
Opposed? Motion carries. This isn't the end of the road. You have some alternatives. The staff will get with you they'll have some options, and make sure you understand what your full rights are. Mr. Garst, thank you for your time.
No problem, thank you,
And
guys.
we'll make sure and get with you on that,
And happy
okay?
birthday to me, right?
Happy birthday. Happy birthday. Happy birthday.
Thank you. I'm gonna meet with the prosecutor outside as yes, or?
That'd be great. We'll
And
meet.
then I'll go and.
Thank you, Mr.
All right, you got
Thank
it.
you.
Okay. All right, so we are now done with the contested cases. I think we're done with the motion for rehearing. Is that right, Pamela? Did we miss anything? Okay. All right, let's look at, actually, we want to look at item I, which is the presiding officer's signature over the orders. So we, the idea simply here is that as we issue out these orders, we want to make sure that each of you guys have an opportunity to look at the orders. But there's kind of a lag in getting them signed. And the idea is simply to have the presiding officer as the chair sign on the basis for the commission of the orders. But you still have full view of them, and there's a vote on them once they're approved. Is that accurate?
Yeah, Mr. Chairman, Brad Bowman, General Counsel, this is just an issue we wanted to put in front of the commission. The idea is to kind of streamline the process. So right now, we circulate all of the orders in the cases that you just decided and all of the other cases that you hear. They're circulated to the commission to get a signature from every commissioner that voted, you know, whichever way you voted in that case. From time to time, we have to take an order back to our office to work on it. If the commission has made some changes in a PFD, for example, and then we send it out to you by email afterwards to get your authorization for signature. So what we would like to do, with your approval, is to, rather than obtaining signatures from every commissioner that voted on that order, we would still circulate the order to every commissioner, and you'd have a chance to look at it, make sure it's correct. Did we show everyone voting the way that they properly? Does the order match what your decision was in the case, and so forth? If we have to email it to you, we would give you, a week to get back with us to let us know if there's any issues with that. But then we would have the chairman sign the order on behalf of the commission at that point. So every commissioner would still get a chance to see every order and to let us know if there's any concern or issue with it. And we think that'll be, again, a more streamlined process, that we can get the orders out to the respondents more quickly. That's the idea, and I'm happy to answer any questions that you might have about that.
Any questions?
I have a question.
Yes, sir.
I'd like to put my own signature on things because I think it's more appropriate due to the fact for multiple reasons. One is that if we have like a DocuSign or we have something to where we already have our time-stamped signature that is validated by us. That's one thing I truly believe in. If you're going to be on a commission or a board or whatever, I'd rather it be my signature than a chairman signing on my behalf, number one. Number two, if I'm an abstention or if I oppose the ruling of the chair, I want my signature to be on there to say that I've opposed what the TDLR commission says. And I think we could streamline that, especially now that we have all of our laptops and iPads working, because if Tamala sends us, can you please review? And all we got to do is just make sure that we sign. I just prefer, as someone that signs a lot of stuff, I like to sign my own stuff. That's just me.
Understood. And that's why we wanted to put this in front of you, to see what the will of the commission is.
Commissioners?
I'm fine with the streamlining, as long as we get our acknowledgement to Tamala or whoever saying we consent to it, not necessarily have to sign off on it. So I think to make it easier for everyone, instead of getting five different signature pages or having to collect DocuSign.
And right now, what we do is we have an electronic signature for each of you.
Right.
We don't ever place that on a document unless we hear back affirmatively from you. So we can continue with that process and try to do the best we can to get that done timely. The process that we would move to, if you were in favor of it, would be we would only have the one signature from the chairman. We would still show how each commissioner voted. Did you vote for the motion or against the motion? But not necessarily have each commissioner's signature. But Commissioner Callis, I totally understand your view on that you'd rather have your signature on the order, and if that's the way the commission wants to handle it, we'll continue. We can certainly continue on with the practice that we've had. Again, the idea was to try to speed up our process so we can get orders out more timely to the respondents.
Can I ask you, Brad, what are the hurdles that y'all have to face in getting that done on our behalf when we do that? Have we been slow in responding to you, or?
I will, well, it's
laughing over here.
The genesis of it was the delay that was occurring.
Particularly the orders that we have to send out to you. If the ones that we circulate here, we already have the order prepared. That's not an issue. It's the ones that we have to send out, and we have to affirmatively hear back from every commissioner, and sometimes that's been there've been some.
Do y'all have like the voting option in Outlook? Where like so if I set up a meeting in Outlook, people can, I'll say, we're going to do A, B, or C. Which do you want to address today? And they'll click A or B or A and C. Is that something that we could do and just check off our signature? Something like that?
It's something we can look into. I'm not a Outlook guru by any means, so.
Like a tech guy to me.
But there may be other technology solutions that we could look at to try to streamline the process as well.
I will tell you that it's probably due to me, most likely, due to the fact that I carry 5 different iPads, because a state iPad is different than a bank iPad, is different than a medical board iPad, different than a liability company chairman iPad. I mean, I got iPads galore. And what my thing is and also too, my iPad has always been dysfunctional. I've had more problems with this iPad. But with that being said, now that we've streamlined, we got it working, I can respond. It's very nice, because whenever now Tamala responds to me, for example, it goes to my private email that dings me right on my phone saying you need to go to your TDLR, and so it streams. I'm just saying, I think I was probably the most delayed, because I had trouble getting into this thing all the time, to be completely honest and accurate for the record.
And Dr. Kells, we appreciate that.
We'll have a conversation with you after class. We're going to have a conversation after class.
We can
But it's not that case. I mean, the idea is a systemic setup, right? For the efficiencies of the state, what do we want to do to get these orders out? And understand that we might not be here in a year or two. There may be a different group of, so I think, in the Brad, and I'm neutral in either way, but the idea was simply to build a system of efficiencies so that the orders can get out without, one, denying each commissioner their opportunity to see the order. 2, making sure that if they don't consent with the order, that disconsent is fully noted for the record. Now, whether it's a DocuSign or whether you have a pen on it, I don't know. But I think that's the context of the conversation. So it wasn't an indictment on any particular one. It's just that, although the squeaky wheel does bark the loudest, I think. I'm just saying.
I'm squeaking.
Yeah, squeak. But it wasn't.
Mr. Chairman,
It was
this
a
was a
setup.
discussion item. If there's action, we can delay it, but we can come back with some more options. More looks.
I'm willing to go to the will of
DocuSign
the commission. So what do you guys
We'll
want to do
explore
with
some
this?
technology
Are
solutions.
you?
He's going to look at some technological solutions, possibly the check box kind of thing.
We'll look
Maybe
into
we can
that.
just check a box instead of signing it and getting it back to you.
If we need to, we can bring it back before the commission, and if it's something we can just implement, then we can do that. And-
Perfect. Okay.
I've always liked it now, because when you just click DocuSign, my signature's there, it flies. That's very
Well,
efficient.
I got a whole side over here that I need to make sure to include. We got Mo and Curly here. All right, how do you guys feel about this?
I think that Jessica reminding, I'm sorry, that's my boss that I have on my mind. Tamala reminding me that we need to sign works, as Gerald said. If it comes to our personal email, then we can go to our TDL,
Okay.
We all have so much going on, so I think that reminder is great.
Okay.
Commissioner, if and maybe just for all of you, just to get a little closer to the mic so that we can pick up the audio I'm
Yeah,
hearing.
you have a
We-
soft voice, so if you don't mind having the audio.
That's a first.
Dr. Weston, you good?
Yeah.
Okay. You want to delay? You good, or you?
I'm fine with delaying. I'm
Okay.
fine with delaying.
All right, we're just going to postpone this, take a look at some other. Okay, great.
Thank you, Commissioner.
All right. On to rules. We're looking at the VSF rules. Who's going to handle that? Salinas?
Good morning, Commissioners.
Good
Elizabeth
morning.
Salinas Strittmatter with the General Counsel's Office. I am here to present to you the draft rules for the Vehicle Storage Facility amendments pursuant to HB 1140 that was passed during the 86th legislature. These rules provide us with a method to calculate storage and impoundment fees for VSFs, which would allow for the VSFs to toggle their fees based on the Consumer Price Index. These rules have been presented to the TOW VSF Board. They were published in the Texas Register on August 16th of 2019. The deadline for public comment was September 16, 2019. We received one comment during that time, which was positive from an insurance company, Canal Insurance, and it was in support of the draft language. On September 23rd, we went back to the TOW VSF Advisory Board, and they voted to pass on the draft rules with no further changes to the Commission, requesting that the rule be adopted as written. The rules be adopted as written. And in addition to the amendments to 85.722, which, as I mentioned, are the storage and impoundment fees, Bill HB 1140 also removes the environmental fee from the statute. The environmental fee was never a fee that ever went into effect, and so it was done away with during the legislative session.
Okay, everybody had a chance to read the rules? Any questions? I would entertain a motion.
I'll make a motion.
Second?
Second.
All in favor, say aye.
Aye.
Thank you, ma'am.
Elizabeth, great job. Commissioners, just to kind of wrap a bow on that concept, it's going to allow for an automatic mechanism in which fees can either increase or decrease for the vehicle storage program. So we wouldn't come back to you for, we need to increase the fees X amount. The index is going to take care of that, so it puts an automatic mechanism in place.
Hey, Tamla, can you ask them to move down the hall, please?
I just did.
Okay, ask.
I just did.
Okay, thank you. Thank you, okay.
Thank you.
All right, Ms. Pello.
Good morning, Wendy Pello, Assistant General Counsel. This is Agenda Item K regarding discussion of proposed amendments to an existing rule under 16 Texas Administrative Code, Section 112.25 regarding the hearing instrument fitters and dispensers program. The proposed rules update the requirements regarding examination proctors. Just a brief background, the proposed rules, the statute requires us to set up rules regarding the proctors who serve, the persons who serve as proctors for our practical examination for this program. And the proposed rule is reducing the number of years a person must be licensed from 3 years to 2 years to serve as a proctor. It also reduces the number of practical examinations that they have observed from 5 to 3. And then it also adds some language recognizing any training that the department or our designee, our exam designee, provides to the licensees as proctors. And the purpose is to allow additional qualified licensees to serve as proctors while still maintaining the training and experience requirements that are needed to make sure that those examinations are done properly and that we have qualified persons to serve. This does affect just those licensees who would serve as proctors. It's a voluntary process, and hopefully this will be able to increase the number of proctors, which allows the examination to be provided more frequently in more locations across the state. Just procedurally, the Hearing Instrument Fitter and Dispenser Advisory Board met on February 7th, 2019, and recommended that the proposed rules be published in the Texas Register of Public Comment. The proposed rules were published in the Texas Register on April 26th, and the public comment period closed May 28th. The department received 2 public comments on the proposed rules. One was in favor of the proposed changes from the Texas Hearing Aid Association, and the other public comment we received was outside the scope of the proposed rules. And so the advisory board met last week on September 24th to review the proposed rules and the public comments, and they voted and recommended that the proposed rules as published be sent to the commission for your consideration. And so we are recommending that the commission adopt the proposed rules as published with an effective date of November 1st, 2019. I'm happy to answer any questions.
Any questions?
So move.
Second.
Second.
All in favor, say aye.
Aye.
Carries. Thank you, Ms.
Thank you.
All right, moving along to, item L. Do we need a break? You good? Everybody good? Okay, item L. We're going to criminal conviction penalty matrix. Mr. Thielen, good to see you, sir.
Good morning, Commissioners.
Almost afternoon, got a few more minutes.
Trevor Thielen with the Enforcement Division. For the benefit of some of our newer commissioners, I also, along with Ken Sharp, handle our criminal conviction cases. Every time somebody applies at TDLR, we're going to take a look at their criminal background. We're going to see if the various laws that we are charged with employing on behalf of the state apply to that person. If they show us that there's a particular concern that a person's criminal history brings forth, if we were also to give them a license. And the Chapter 53 sections that allow us to make those decisions in some of our cases to deny licenses also require us to go through what you're going to do today, which is approve criminal conviction guidelines. The guidelines are there to give notice to the public and agreement internally about the types of offenses that might be concerning for that particular occupation and the reasons why, and try to explain that as clearly as possible. Now, generally, we go to our advisory boards when we put these together, but today we're talking about the offender education programs, a relatively new program for TDLR. These are the folks who teach the classes ordered by probation. When somebody is required to take a drug offender education program, DWI education program, DWI intervention program, or an alcohol education program for minors, they have to be licensed with us. We don't have an advisory board for that program, so what we did was on July 18th, we held a forum here in this room. We invited offender education instructors to come and give their input, and we had a great meeting. We had over 17 people show up, and we had a really engaged audience. I also want to thank the TDLR staff that was there. We had Chris Russey, Dustin, also from enforcement. We had John from education and examination. We had Ken Sharp. We had a great discussion that day and a lot of input that crafted some guidelines that are going to stray a little bit from what you're used to seeing, and I'm going to try and highlight some of those differences. But before I get into the nitty-gritty, I just want to assure the newer commissioners especially the same thing that we talked about there in the room. These are categories that potentially might justify us doing something with a license. They open the door to that. They don't shut the door. They are not a definite, this person can't have a license ever if they fall into one of these categories. Instead, it's just guidelines on these are the cases we should probably take a closer look at to make sure there's no glaring problems. So I'll go through them real quick. Crimes against the person, such as homicide, kidnapping, and assault, is almost universal throughout our criminal conviction guidelines. The concern there is obvious. We're giving a person a license that puts them in contact with other people. We don't want to give it to a clearly violent person who may instigate fights or attacks or, even worse with that person. Then we start veering off into categories you might find unusual. We start with crimes involving gambling. The concerns that the forum members had for us is that, if gambling's illegal in Texas, and oftentimes if you're going to gamble in an illegal situation, and really we're talking about illegal gambling, not legal gambling. You go across the state or you go to a legal casino. That's not what we're talking about here. Illegal gambling often happens in the context where somebody's set up a place where there might be alcohol use, illegal drug use, other illegal stuff going on. A person who's comfortable going into those situations is probably not the best person to be then a role model teaching folks about how to avoid temptation, avoid addiction, of dealing with drug, alcohol issues, and that goes to the core of what these instructors teach. So that was one of the reasons, as well as the public confidence that they have. If an instructor is constantly getting in trouble for illegal gambling, that really looks kind of bad from the perspective of the state sanctioning this person to be the person who teaches our probationers who are making a good faith effort to get back on the right track. The next category, crimes involving illegal weapons. The concern there from the forum members was we are putting folks who have gotten in trouble with the law into a room, classroom, potentially against their will. Sometimes things get heated in those environments, and we need instructors who are there to calm things down, to find alternative ways to resolve any arguments or conflict that erupts into that situation. It was important that we highlight these are crimes involving illegal weapons, not legal weapons. Someone who is going to commit a crime who carries an illegal weapon, that person might not be the best person to diffuse the potentially volatile situations that we encounter in the classroom. The next section, crimes involving intentional cruelty to animals. This was one that came to us from the forum members. We didn't propose it. The concern there was what does it say if someone is intentionally cruel to animals? It's kind of a disconnect. How does this have to do with teaching a class? And we talked about the broad different ways that you can commit cruelty to animals in Texas. Some of those are neglectful. You don't feed your animals, you keep them tied up in the sun, stuff like that. That's not intentional. What we were getting at was the sort of torture type offenses in cruelty to animals. And what the forum members were telling me is, look, a instructor has great amount of control and power over the life of that probationer. And if we're dealing with someone who seems to find pleasure or entertainment in torturing animals, they might also be of a concern to be in that place of control over human beings as their job. The good news is we see very few, from my perspective, of reviewing these cases every day, I find very few in cruelty to animal cases, and I think even fewer of those are going to be the intentional cruelty to animals. But I thought it was an interesting one to put in there, and the forum members made a good case for it, so we are including it here. Crimes involving prohibited sexual contact. This one's also pretty universal throughout the other programs that we have. We don't want someone who's coming into contact with people potentially be dangerous sexually. But we've also got the added element that our offender education program instructors do have a great amount of leverage potentially about over the lives of their probationers. They may make the decision between passing them or failing them from a class, which could be the difference between that person going to jail or staying free, of them being able to provide for their family or not. So we need to, the concern is also, could an instructor use that leverage to coerce some sort of sexual misconduct or sexual encounter with a student? So if they have prohibited sexual conduct in their past, that'll be something that we can consider. Crimes involving minors as children, minors as victims. There was a great amount of discussion about the distinction between using the word minors and the word children, because in this program, one of the classes they teach is alcohol education program for minors. And we wanted to be real clear that we don't use the word children, because I think children generally we think of that up to 18, but minors could be all the way to 21. They're setting a standard for minors who may not be children to follow when they teach that alcohol education program for minors class. So that was one point of discussion brought up by the forum members of why it's important to use that word. They're going to be teaching minors and sometimes minors who are also children. We need to make sure they are safe instructors to trust with that responsibility. Crimes against property, such as theft and burglary with intent to commit theft. The concern there was eliminating another category of offense you usually see in the crimes against property section, and that's criminal trespass. There really wasn't a way that we could think of that trespass was really connected with anything that an instructor might do. But when we dialed down on theft, there were a great number of opportunities that an instructor could use recommit a theft offense. they have access to sensitive personal information of their students. Sometimes they have access to the classroom equipment owned by the instructor company. And they also have access to class completion certificates, which could be a valuable thing. They could steal that from the instructor, sell them on the black market. So we really wanted to dial down on what theft might say about an instructor applicant and be able to use that. Similarly, crimes involving fraud, forgery, or deceptive trade practices, the concern there is that this instructor is the gatekeeper, making sure that the certificates that show a person completed the class are actual, genuine, not false, that they're not persuaded to make copies of certificates, sell them elsewhere, to fudge the records for a class to make it look like somebody appeared because they bribed them. Finally, we're in the home stretch, crimes involving drugs, and we tried to describe this as broadly as possible. If you're tasked with teaching people who have been caught on drug crimes, not how to fight their addiction, how to avoid those situations in the future, we can't have those folks also dealing with drug problems in their lives and all the attendant crime that comes out like tendrils from the attempts to get illegal drugs. And finally, we also have another broad category of everything that involves alcohol. 3 out of these 4 classes that are taught are dealing with folks who have generally gotten DWIs or DUIs for minors. They need to be able to set the standard for their students. They need to be sober and in control when they are performing their jobs. They need to be trustworthy examples to the community that we are doing something actual about folks dealing with alcohol addictions. And we can't have somebody who's also suffering through an addiction themselves, who's too recent from the same types of crimes they're trying to teach others to avoid teaching those classes. With all of that said, I'd be happy to answer any questions about these, but at the end of the day, I'm hoping that the commission will approve these criminal conviction guidelines, and we can get started posting them on the website and using them in our cases.
Great job, Mr. Thielen. Appreciate their efforts on that. I know it's an arduous task, and appreciate them.
You're welcome.
Questions from the commission? I'll entertain a motion.
Make a motion to approve.
A second?
Second.
All right, all in favor?
Aye.
Motion carries. We're going
Mr.
to take
Chairman, if I could just add a couple more things. One, I want to commend Christina and her team for putting this together. This is a unique gap and void that's existed to have this for the first time, but I really want to tip my hat to Trevor. I had an opportunity to stick my head in that session, and it was impressive. You had a group of very passionate, very proud professionals who, one, were being asked for the first time their opinion on who should get their profession, what are the crimes you should look at. They felt honored for that, but then to watch their deliberation back and forth, how they wrestled with issues about who should be up in the front of the room, and Trevor being able to articulate our values of what's important and why we have this process, I was humbled by it. He is an incredible example of our core values in action: open, free communication, integrity, respect, innovation. He just did a great job, and it was one of the best examples I've seen of TDLR in action in a long time. So I really appreciate what you did, Trevor.
So in that same vein, but I want to tell you, commissioners, this agency is expanding in an incredible pace because of what we do and how we do it. It is going to be beholden upon us to hold these types of meetings and to get stakeholder input. We had one yesterday with anti-human trafficking, and I think we need to be very aware. You guys, we are not our agency that was 5 years ago, and it is dynamic, and so the more stakeholders involved in these conversations, the better agency will be. So look for more of these types of community town hall engagements, because I think that's going to be who we are. We're going to take a 5 minute to break, and then break, and we're almost home stretch. Back to order. It is 11:45. Shirk, criminal conviction under vehicle storage facilities.
Mr. Chairman, members of the commission, Michael Shirk with the Enforcement Division. I'm specifically a prosecutor working the towing and vehicle storage facility programs. We're not really dealing with criminal convictions right now. What I'm presenting to you are proposed revisions to the penalty matrices for both of those programs. Just by way of background, just about every program has got penalty matrices. And what these do is they classify violations of the law, whether they're the statute or the regulations, into certain hierarchies of importance. So A, B, C, D, E, F. A is the least severe penalty. G is the highest penalty. These first off give our license holders fair notice of the penalties which they may be subject to if they violate the law, but they also give us some limitations on discretion so that people who engage in the same kind of misconduct get the same penalties. As you know, the towing and storage program has an advisory board which consists of subject matter experts representing people from insurance, law enforcement, owners of towing and vehicle storage facilities. What's coming before you right now is a result of a vote taken by the advisory board on September 23rd to forward for your attention and adoption changes to the penalty matrices for both the towing and the vehicle storage facility program. The way the process began was that the advisory board created a working group of Jeanette Rash, Jimmy Zaluka, Tasha Mora, and Joanne Messina, myself, and Tony Reed, who are the prosecutors in this program. We sat down on a number of occasions and worked through the pre-existing penalty matrix. One of the things that we wanted to do was to get rid of definite penalties for violations so that depending on the specific facts and circumstances and history of a licensee who was found to have violated one of our rules, we could take into account those specific factors rather than charging everybody with a $900 penalty or a $1,200 penalty. We could look at, was this a good faith error or was this a calculated and systematic business practice so that a first violation, a second violation could involve some discretion. And this has been the tendency through all of our programs, is to move away from set penalties where A, B, C had to have a certain penalty to affording greater discretion to the prosecutor so that we could take specific account of the facts surrounding the violation. I think I speak for everybody involved in the process in saying that it went exceptionally well and that the various interests which were represented, staff as well as industry representatives, realized that we sought the same outcome, which might generally be described as permitting more discretion in the assessment of penalties, while also trying to diminish the amount of regulatory burden on our licensees so that they could comply with the law. They would have an incentive to comply with the law without wondering exactly what the law required of them. We believe that what is presented to you right now serves the legitimate administrative purposes of general and specific deterrence, and I'm going to just walk you through them so very quickly because, as an example of how well staff and the advisory board member worked, we're in complete agreement with everything that's presented to you today. So it is, except for one point, staff and the advisory board members are requesting your adoption of these revisions that were in your materials. The only area that staff and our advisory board members differ is in the towing matrices, and if you turn to page 3 of the proposed vehicle towing violation, you'll see Class B. And what we did throughout both the tow and the VSF program is we consolidated classes so there wouldn't be so many. It would be simpler. We have just 4 now. What has been proposed by the advisory board is, if you look, page 5 is a Class B, which consolidates what used to be the Class C and D. On page 5, then, you'll see that there is a whole list of illegal tow violations: towed an unattended vehicle other than permitted by law, towed a vehicle due to an expired license plate or registration without required notice, removed and stored an unauthorized vehicle other than when allowed by law. And I'm again looking at page 5. You'll see notations on each one of those that those were moved to the consolidated new Class B from the Class F. What that means is that for a first violation, the license holder would be subject to a $500 to a $1,500 administrative penalty, and/or 6 months suspension up to full suspension. These came from Class F. Class F permitted for a first violation a $2,000 penalty for a first violation. So what we're looking at is slightly diminishing, in a way, the first violation for a wrongful tow. You know, of course, that is what our law insists upon in the first instance, that every tow be conducted in conformity with the law, and we expect tow drivers to understand that law. But there is a difference between a person who's not paying attention and somebody who's just trying to pull as many vehicles as possible. So staff is requesting that the illegal tows that you see moved from Class F to this consolidated Class B on page 5, those top 4, remain with a $2,000 penalty, as you would find for the Class D, which is contained on page 9 of your materials. That permits a $2,000 up to a $5,000 penalty for a first violation. Apart from that distinction, staff and the advisory board, after our working group and after being presented to the advisory board on September 23rd, after their unanimous vote to adopt these, is presenting it to you for your vote. You don't need to send it anywhere else. Your vote puts these into effect. The only distinction being whether or not those illegal tows that I pointed out on page 5 remain as requested by the advisory board in what's the Class B, or whether or not you return them to their original $2,000 penalty in the Class D. I'm here to answer any questions that you may have.
I'm counting 4, you said 4 or 5? I'm counting 5.
Violations?
Right, that.
I'm looking at page 5 right now. Towed and unattended, towed due to an expired, removed and stored unauthorized other than allowed by law, and performed a non-consent tow from at least right-of-way.
I towed a vehicle from parking facility. Did you get missed on?
That's right. That would have been an F as well on the previous page.
So it's 5.
That's 5.
Make a motion to approve as written.
Second.
With that stipulation, right? Keeping it in D.
As written is as proposed by the advisory board.
Correct, correct. I want to make sure all commissioners are aware of what we're looking at, okay? By the way, before that, this is tedious and it's granular, and I appreciate what you guys have done. This is
Oh, but it was so important, because one of the things that we were able to do is we were able to participate staff in saying, what's really coming across our desk now? What do we really need to address in an aggressive, muscular, and unambiguous way, as opposed to some of the other violations that we didn't need to have those penalties. So it was granular, it was tedious, but it was well worth the effort.
No, it's a great job, and the reaction is quick now, and I love the way we evolve our rules quickly to adjust these, because it moves.
Yeah.
It moves. All right, so the motion to adopt?
As written.
Is written second?
Second.
All right, all in favor, say aye.
Aye.
Opposed?
All right, thank you.
Mr. Chairman, Brian Francis, I'm not going to embarrass Mike like I did Trevor.
Good.
But I will tell him bravo and great job. But I do want to go on the record, and Commissioner Butler will probably be aware of this, but there are some individuals in the towing industry that have always had concerns about the penalties and how we apply them. I'd received some information that implied that this was worsening the situation. That is completely opposite. If you look at the language, our staff did, and I commend them, when they combined those categories and those classes, they changed the world. They lowered the starting point and they lowered the ending point for penalties that were $1,200 to $2,400. Now it starts at $500 and goes up to $1,500. They made a marked change in how we are assessing those, and part of it ties and goes hand in hand with Christina's team and their philosophy, that we are also getting money back to those individuals that have been towed. So the restitution piece of putting money back in the pocket of the consumers that have been towed improperly, and the penalty piece, both of those together is providing that consumer protection, that holistic approach that we want to take as an agency. So, bravo, and Mike is a very, very well-respected national expert on this. He's been sought out for different conferences, so great job. And this is monumental.
No.
From where we started with this program and where we are now, it just continues to improve and just really fine-tune it.
And I want to highlight the fact that this recent flooding in Houston, right, and how quickly Brian and I were on the phone, it was still raining. Actually, I was at the ranch, and it was still raining when before the governor declared the state, and we were able to react to it. But the vehicle, I mean, this is such a, people they underestimate the impact to a metropolitan area if you can't get these vehicles moved. You can't do it quickly and properly, and the owners aren't going to be taken advantage of. So you guys being on this is, I mean, this is a big deal in many ways. So, because it's just no matter if it's going to happen, when the next disaster happens, and we react to it. So, well done.
You can definitely be proud of this, and Commissioner Butler, if you need some assistance in responding, you can be proud of this as well.
Oh, yeah, yeah.
All right, so Sunset Commission, we want to talk about that. Eric Beverly? You still have all your hair. You look okay. You sure all right?
Mr. Chairman, we treat Eric Beverly like he's Ohio State University. We put "the" in front of his name.
I'm
The
sorry,
Eric
Eric
Beverly. He tried to get
Good morning,
a
Chair
He's in a
Figueroa,
good
Vice
mood
Chair
today,
Butler,
Eric. He's in
and
a very
Commission
good
members.
mood. Good time to ask for a raise.
It's good to see you. Good to see
Is that on the agenda? I hope you have a handout that looks a little bit like this. Okay.
They're behind you, Eric, so just.
The Eric.
The Sunset folks are behind you, so be
They
careful
are.
what you say.
And in fact, now would be a good opportunity to introduce the Sunset team. So you'll see Emily Johnson is the project manager. Eric Fajardo is the review director. We also have Rachel Gandy, Michaela Garrison, Sadie Smeck, and Jaime Puente.
Good to have you guys here.
So since I last presented to you, we have submitted our self-evaluation report, and that kicks off phase one of the three-part review structure for the Sunset Commission. I want to extend my thanks to Commissioner Collier, Drs. Callis and Wesson for their review of the self-evaluation report.
Well written, by the way.
Thank you very much. And would also like to extend my thanks to everybody at the agency, and it was almost everybody at the agency, who helped provide information and fact check and ensure that we deliver the product on time. So Sunset staff will be with us from October through May of 2020, conducting their staff research and evaluation of our agency, the ongoing need for the commission and the agency, which is the main question. They have already begun to review our self-evaluation report. They will be doing extensive outreach to ensure that anybody who is affected by the agency, any member of the public, has an opportunity to weigh in and provide their ideas and feedback for making this agency more fair, transparent, effective, and efficient. They will, of course, develop recommendations. Some of those will be statutory recommendations, and some of those will be management recommendations, which generally take the form of either changing rules or a policy. And they will publish their staff report in the May timeframe. And then that kicks off phase two. After they publish their report, typically about a month after that report is published, the Sunset Commission will meet to deliberate. Well, not to deliberate, they will meet to take in public testimony. That will be an opportunity for Sunset staff to make the presentation. We'll be asked to testify as an agency, and members of the public, folks that are in affected industries and professions, anybody who has an interest in the agency will be able to participate at that public hearing. And then generally about a month after that, the commission will reconvene and they will have a decision meeting. And typically public testimony is not taken at that time. That's a time when the commission can accept, modify, or reject any staff recommendations. They can also bring forward any new issues that may have been brought up to them. And then the third phase will be legislative action, and the Sunset recommendations that require statutory change will be rolled into legislation, and that will go through the regular process like other bills during the session. So that concludes my summary, other than to say we are meeting
Tomorrow, we'll have an introductory meeting with Sunset staff, and then we will provide a general agency overview. In addition, we have 13 other meetings scheduled in October where we will be providing more granular and division-level reviews for Sunset staff, and also talking about the various programs that we regulate.
Mr. Chairman, we will continue to fold the commissioners into all these conversations. So for all the meetings that we do, whether it's the overview tomorrow or the 13 division meetings, we're going to provide the work group with the information that we're providing to Sunset and be available for any questions they may have as we navigate and meander through this process. I've said it before, and I want to tell the Sunset staff this. We welcome this opportunity. We know at the end of the process we're going to be a better agency. I'm proud of who we are. I know we're not perfect. And so I look forward to having this microscope placed on us and giving TDLR the tools and the focus to be the best agency that we can capably be. And I'm excited about it. The conversation in Eric's leadership on the self-evaluation report, that document is the most comprehensive, thorough, and well-written document on TDLR that we've ever had. And I would encourage you, if you have time to go through the 279 pages, to do it, though, because if you want to know who we are and how we do our business and what we believe, it's in the document. It's fantastic. Great job.
Thank you.
If I
Thank
could,
you.
if I could, Mr. Chairman, I would like to thank Eric. He did an incredible amount of work. I can't do GPS either. You can ask Mike Arsmendis. You did some seriously heavy lifting on behalf of the whole agency. Thank you so much for your work. This sets the blueprint for us.
Thank you, Carl.
Thank you. And the commissioners, it's a great process for us to Mr. Francis' comment, for you to kind of get a very global, holistic view. But as a recovering auditor, right, I mean, process improvement never is complete.
That's right.
So I'm always excited about this and the control points associated. And thank you so much for the efforts. I know, Cal, you guys poured in. You're running point. I know Dr. Weston's here on this as well. So whatever resources you need from us on the commission, let us know. Thank you, sir. Good luck.
Thanks,
And don't age.
I'd like to note that Eric and I went to the same high school.
But he graduated.
Oh, that's-
Moving on. Better if you don't say that. The power of the gavel. Power of the gavel. All right, so, Mr. Francis, I think it's your time, sir.
Mr. Chairman, Brian Francis, I just want to touch on a few things in the executive report. Number one, we also want to extend a very hearty welcome to our newest commissioner, Commissioner Castaneda. We had an opportunity to spend pretty much a full day with her yesterday and going through the new commissioner orientation. She was able to witness firsthand the depth and the wealth of talent that we have in this agency. Our directors, our OSC team, all of them, they showed out and they showed up, and I'm proud of that. But she's going to be a fantastic commissioner. She is not shy. She is not shy at all. She is going to tell it like it is, and I think that's going to be an awesome addition to what we have at the commission. I appreciate her being here. The other thing is Mr. Arsmendis is out of training for the Governor's Executive Development Program. They do 3 week-long sessions. This is the second session, so he would have been here had he not been in that training. I also want to get the commissioners prepared on the November 5th meeting. That will be our Deputy Executive Director, Carla James' last meeting, so govern yourselves accordingly.
And he told me yesterday I didn't have to come.
I know. And she had like one day of thinking that was true. It was awesome. But I'm available to answer any questions you may have.
Any questions? All right. Before you, commissioners, is the assignment commission work groups. Carla, you have anything? I'm sorry, I got to dig those glasses. I'm not sure where you got them, but
I keep trying to get you to wear them, but you refuse.
later. Do you have any comments for your staff report?
Nothing out of the ordinary other than they're just awesome.
Okay, awesome, good. Before you, commissioners, you have work group assignments, and I want to emphasize this. I mean, we went through a transition on the commission. As we went through this transition, we needed to reassign. What I did is we created a heat map for these advisory board liaisons, because each advisory board is not the same. And as these pop up, we want to make sure that we want a voice, or at least have an ear in these advisory boards, because they are our feet on the ground, and then where rubber meets the road. So your assignment to these boards are here. I would love for each of you guys, at least minimum, you can tune in via Skype and if you want to speak to the advisory board, you're capable, they'll be able to add you in. So I know it's difficult for us to travel to Austin, and we're all busy, and I'll double your pay if you get here. But the fact is that it's good to have an ear here, because this is where a lot of stuff gets discovered, and they can tell us a lot of what's happening. Above that, you see the commission work groups, which is the audit finance, which we met earlier. Thanks, Mr. Butler, for doing that. And then the bill implementation, human resources, and then innovation, and sunset and strat plan, which we talked about earlier. Couple of things is prisoner reentry is a big part of who we are. It's going to be what I want to focus on, as well as anti-human trafficking. These two are major issues that, as a chair, I want to make sure that we push forward. I'm sure you might have others, but there is probably, in my mind, as a commission, no greater challenge in front of us. The inventory of talent in our state at anything below 5% unemployment is a thin margin for growth, and we are able to provide an inventory increasing through our prison system and the vocations that we offer. So I've asked Dr. Wessons, and I've asked Commissioner Butler to spearhead. I think you've already visited some facilities about how to get these licenses there to make sure the safety of our citizens of the great state of Texas are paramount, bar none, but equipping and reducing the recidivism rate associated with these individuals is important. So, but also, as you well know, and it's been highlighted in the news, that human trafficking is an issue. We in our vocations and our licensing, we're in the middle of it. We had a great meeting yesterday with the enforcements, and I think we want to continue that. So I wanted to highlight those two. If you have any questions, or if you wanted to be modified, you want you to change your assignment, let me know. They're here in front of you. Any other comments about that, Mr. Francis?
No, sir.
Good. Okay. Next commission meetings, I think Tamla sent us some information about the next few commissions meetings, towing and contract services. You have them in front of you. If you can make it, again, dial in. If you can't, I think our next meeting will be motor vehicles. Did you want to make a comment about motor vehicles?
Mr. Chairman, we're moving swiftly with that. The only thing I'll say about motor fuels under, Brad, I'm going to return to my executive director report for recent accomplishments and current projects. So that's a current project, and we will be getting the applications up for the motor fuels work group. That work group is created by statute. They're actually appointed by me, but we'll have the same mechanism for having the applications received online and start reviewing those. That's really the big one. The team is working very well. Mike is leading up our efforts on the management side of that transition as we continue to go through it. Brandy's one of our leaders in regard to monitoring our contract compliance. And then Randy Nesbitt is over the transformation arm. Basically, while we're doing the work we have to do today, are we meeting the contract terms today? We're also taking that long-term look of what can that program be in 6 months and 9 months. And so there's a lot of moving parts on it, but it's moving well. We have found some great cooperation with some folks over at the Department of Ag, and we're really using that to our advantage. So it's really been going good.
Motor vehicles, there is a force. There's a crime syndicate of skimming. There's a lot of issues going on with how this operates. We've taken this on. The legislature's been giving us that responsibility. We need to embrace it quickly, and we need to ensure the transition is as smooth as possible. So anything you need from us as commissioners, make sure you let us know any resources, because that's the front burner as well. So.
As we move down the road, we're anticipating a very public rollout of new decals that will go on the dispensers, and that really is going to be a defining moment for our vision and our approach on protecting the pumps, that we all have responsibility in it, whether it's the consumer, whether it's the gas station, and whether it's TDLR. We all have a responsibility for helping to protect those pumps, and you're going to see that folded into the decal, and we will have we're going to have press conferences throughout the state and we would definitely want the commissioners to be a part of those conversations as we go around. And we'll let you know as we get closer to that date.
After this, we'll go ahead and solve the Middle East crisis while we're at it, right? All right, so November 5th, any other comments, commissioners?
Mr. Chairman, if I could, I'm told that our fuels application is already up, and we are already receiving applications.
Good.
And as a parting gift for me, Brian has agreed to put my picture on all the stickers.
It's holographic, so you got to look at a different angle. You know? There's a halo on one, there's another image on another.
Good luck with it.
Yeah. With my glasses on.
I don't think you want your picture on those stickers.
You are 100% accurate.
Exciting. You got a great team. We're young, we're dynamic, and we're going to do well. So I'm excited. Thank you guys for what you do and all the information that you give us. So November 5th is the next.
10th?
December 10th, okay.
Yes, sir. And then our 2020 meetings will be February 4th, April 7th, and June 1st, if the commission agrees.
Okay. Let's do this, Tamla. Let's send that out, because I know Collier and Callis, and I'm not gonna, we'll get that and we'll confirm that. Trying to give you as much lead time as possible. Again, you guys, the agenda gets full or it gets emptied based on the contested cases and stuff like that, so we don't want to call you to Austin unless we really need to, because I know your time's valuable. So we'll try to mitigate that as much as possible. Tamla, thank you. Thank you.
Thank you very
And
much.
would you like to introduce somebody, Mr. Francis?
I would like for her to come in so she can be introduced. There's a little bit of tape delay. So she just now heard it.
She just now heard it?
Here she comes.
You thought I forgot, didn't you?
Yes, because I did.
Actually, you forgot.
I know.
You forgot.
I was going in.
I remembered, which doesn't happen very often, but that's, if you don't know, Brian's got a new babysitter. So,
Not me.
that's pretty much.
Commissioners, I'd like to introduce my new executive assistant, my new partner in crime. She's talented. She's worked in licensing. She's worked in enforcement as well as RPM. And she is an incredible addition to our team, so I'm very grateful to have Yvonne Campos here with me by my side.
Welcome and good luck. With that, we'll adjourn.